respondent. So I'll deal with the ruling in respect of the motion by the petitioners, which was filed on the 30th. A, an order striking out the entire reply of the third respondent to the petition for being grossly incompetent. Or in the alternative, B, an order striking out paragraphs 1, 2, 3, 4, 5, and 6 of the third respondent's reply to the petition for being extraneous to the petition and thus incompetent. There are 4 grounds upon which the prayers are premised, and is supported by an affidavit deposited by Jedidia Daudu. The third respondent, as it was to be expected, filed a counter affidavit and a written address on the 20th of May 2019 to oppose the application. Submitted 4 issues which he said called for determination in this motion. And I will read them. 1, whether the reply of the third respondent to the petition is competent in the absence of the National Identity Number, NIN, of counsel who signed the reply shown or reflected on the reply as mandatorily required by the provisions of the mandatory use of National Identification Number Registration Regulations 2017. 2, whether the challenge of the qualification of the first petitioner to contest the presidential election raised in the reply of the third respondent to the petition, which was filed outside the 21 days stipulated for the filing of election petition, is not stated bare. 3, whether the qualification of the first petitioner to contest the presidential election of February 23rd, 2019 can properly be raised in the third respondent's reply to the petition. 4, whether the contention of the third respondent that the first petitioner is not qualified to contest the presidential election on 23rd of February 2019, not having been supported by any relief, is rendered incompetent for being hypothetical, academic, and speculative. And 2, having regard to the peculiar circumstances of this petition, whether the petitioner's motion seeking to strike out the third respondent's reply to the petition or the instant application is meritorious and grantable. And Learned Senior Counsel went on to argue their issues. And after a consideration of the arguments by the Learned Senior Counsel, I went on to determine the merit of the application. And I started with saying, by a mere glance or visual observation of the signature on the motion paper and the signature on the written address accompanying the motion paper shows similarity in the 2 signatures, indication the motion paper and written address were signed by the same person. And I find that the motion and the written address were signed by one and the same person. And I find that under Section 101(1) of the Evidence Act as amended, and the authority of FCMB PLC against CP Tech Construction Company Limited, a case decided in 2015 and citation set out, empowered this court to compare signatures and form an opinion on them. The written address has the name tick. The written address has the tick name of counsel that signed it, and his NBA seal identified as Jude Daniel Odi Esquire, showing both the motion paper and the written address were signed by an identifiable legal practitioner, Jude Odi Esquire, whose name can be traced to the role of legal practitioners. Both processes are therefore competent in this petition. The application is titled Motion on Notice, and it has prayers in form of reliefs stated on page 1 thereof, and the grounds upon which the application is based is also contained on page 2 thereof. It is therefore not a notice of preliminary objection. Paragraph 47 of the first schedule to the Electoral Act entitles any of the parties in an election petition to file an application by way of motion on notice in these words, and I set them out. The petitioners being parties in this petition are therefore entitled to file the present motion on notice. Paragraph 47(2) of the first schedule to the Electoral Act uses the permissive word may in respect of filing an affidavit in support of the motion. Consequently, unless an affidavit is necessary for the application by way of a motion on notice, the parties or party filing the motion need not file an affidavit in support of a motion. The third respondent cannot therefore be right in the submission that every motion must be supported or must have a valid affidavit in support of such motion before the motion will be competent. In my opinion, paragraph 3 of the affidavit in support of the application contains statement of facts not extraneous to the matter by way of objection, prayer, or legal argument or conclusion, and does not offend section 1152 of the Evidence Act. The objection to the said paragraphs of the affidavit in support of the motion is accordingly untenable and is hereby rejected. Now, Regulation 11U made pursuant to NIC Act provides thus: in accordance with the provisions of section 27(1) of the Act, the use of the national identification number shall be mandatory for the following additional transactions: filing and registration of criminal and civil actions in courts and other arbitration processes. The Supreme Court, like we pointed out in an area ruling this morning, in the case of Marafa, APC and Marafa, cited by the third respondent, in relation to section 27 of the NIC Act and regulations made thereon, held thus, and I repeat again, section 27 of the National Identity Management Commission Act 2007 and its regulations are not part of the rules of this court and cannot therefore apply to the proceedings filed in this court. Clearly, I find no merit in the preliminary objection. Accordingly, same is hereby overruled. End of quote. The first leg of the relief supplied in the motion paper seeking to strike out the third respondent reply to the petition for violating the NMI Act or failure to insert the national identification number of the third respondent senior counsel that signed it is therefore untenable and is hereby rejected. Paragraphs 1, 2, 3, 4, 5, and 6 of the third respondent's reply of the petition read thus, and I set them out. Then paragraph 12(2) of the first schedule to the Act provides, and I quote, where the respondent in an election petition complaining of undue return and claiming the seat or office for a petitioner, or petitioner intends to prove that the claim is incorrect or false, the respondent in his reply shall set out the facts or figures clearly and distinctly disproving the claim of the petitioner. End of quote. What this paragraph contests the election. The person whose election is complained of is by section 137(2) of the Electoral Act referred to as the respondent, while section 239(1) confers on this court the jurisdiction to determine whether the person has been duly and validly elected to the office of the president or vice president, thus limiting and circumscribing the jurisdiction of the court to the issue whether the person whose election is questioned was validly elected. It does not extend to determination of whether any of the petitioners who is challenging the election or return of the respondent was qualified to contest the election. The fact that the petitioner pleaded that the first petitioner had the right to be voted for and returned in the election to the office of the President of the Federal Republic of Nigeria would not enlarge the jurisdiction of this court under Section 239 of the Constitution, which, along with Section 137(2) and 138(1)(a) of the Electoral Act, as parties cannot and do not, even by consent or acquiescence, confer jurisdiction on the court. I made reference to some cases. It is accordingly my view that the issue of qualification or disqualification of the first petitioner to contest the election is only a ground for challenging the election of the person returned, the second respondent hearing, and not a defense or a reply to the petition. In the result, I find substance in the second alternative leg of the motion paper, impugning paragraphs 1, 2, 3, 4, 5, and 6 of the petition, which is hereby granted, and the said paragraphs of the third respondent reply to the petition, challenging the qualification of the first petitioner to have contested the election in question, are accordingly hereby struck out. I also made reference to the case of Adigun and Fashobo Supra. In conclusion, this motion succeeds only in respect of the second arm of the relief sought, which is hereby granted, while the first arm of the relief, which is not made out, is hereby refused and it is dismissed. My learned brother to my immediate right will pronounce his own decision in respect of this motion.
I agree with the ruling just delivered on this motion.
My learned brother to my immediate left would also say his decision in respect of this motion.
I also agree.
My learned brother to my extreme right will now say his own position in respect of this motion.
I agree.
My learned brother to my extreme left will also pronounce his own decision in respect of this motion.
I agree.
Gentlemen, I now deal with the second motion filed by the third respondent on the 14th of May 2019. And the motion primarily prays for the following reliefs or orders. An order of this Honorable Court striking out Part A of the petitioner's reply to the third respondent's reply to the petition, dated and filed 18th of April 2019, for being incompetent and in violation of the mandatory provisions of the Electoral Act 2010 as amended. It also seeks an order of this Honorable Court striking out paragraphs 1 to 21 of Part B of the petitioner reply and or entire petitioner reply to the third respondent's reply to the petition, dated and filed on the 18th of April 2019, for being in gross violation of the mandatory provisions of the Electoral Act 2010. Also seeks an order of this Honorable Court striking out all the witnesses' statement of oath filed together with the petitioner reply to the third respondent reply to the petition, for being irregular and in flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2010 as amended. And the prayers are premised on 15 grounds which are set out. And the motion is supported by a 26 paragraph affidavit, as well as a written address. The petitioner has opposed the application and filed a 6 paragraph counter affidavit, which is also accompanied a written address. In the written address, the third respondent submitted these issues for consideration, 2 of them, and they are whether this is not a proper application, to be heard and determined by this honorable tribunal before or outside during the pre-hearing session. And 2, whether the petitioner replied to the third respondent replied to the petition dated and filed on the 18th of April 2019 and or the offensive paragraphs therein, together with all the accompanying statements on oath and the purported preliminary objections embedded therein are not incompetent and liable to be struck out in the entire circumstances of this petition. On their part, Land Senior Counsel formulated also a single issue, which is whether the said averments reply and the accompanying written statement offend the provisions of section or paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act 2010 as amended and are liable to be struck out. Went on to consider first the objection by the applicant to the motion, and then I went on to discuss and determine the sole motion in the motion. After a consideration of all the submissions on the objection as well as the merit of the application and the issue raised, I went on to say that the real issue in controversy in this application is whether the petitioner's reply to the third respondent reply to the petition dated and filed on the 16th of April violates paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act, which provides thus, and I set it out. A petitioner, by the above provision, in reply to the respondent's reply to the petition, shall not include or bring in new facts which are capable of amending or adding to the contents of the petition. The petitioner's reply must not introduce any of the requirements of paragraph 4b of the said schedule. The petitioner is also prohibited by paragraph 16 aforesaid from introducing pleadings that would infringe paragraph 14(1) of the first schedule to the Act. Otherwise, the reply will be treated as void and liable to be struck out. This is because the Electoral Act 2010 does not permit a petitioner to hide under the guise of filing a reply to the respondent's reply to the petition to set up a different case from what he already had relied upon in the petition. And I made reference to some cases in respect of this. I have calmly scrutinized the petitioner reply to the third respondent's reply to the petition, particularly part A, dealing with the preliminary objection, and I am of the view that paragraphs 1 to Roman 1 to Roman 18 thereof do not offend paragraphs 16(a) and (b) of the first schedule to the Electoral Act, as all the paragraphs contained in the third respondent's reply to the petition, paragraph A, notice of preliminary objection, raised new issues of facts in defense of the petition, which the petitioners have not dealt with in their petition. In respect of part B of the reply to the third respondent's reply, the petitioners raised objections to paragraph 1, 2, 5, 1, 2, 3, 4, 5, and 6 of the third respondent reply, contending that the matters relating to the qualification of the first respondent ought to be by way of a formal petition within 21 days after the date of declaration of the result, and that the said paragraphs touching on qualification cannot be done by a reply. This issue has been resolved in the ruling just delivered in the petitioner's motion of 13th of May 2019, challenging the said paragraphs of the third respondent's reply to the petition, dealing with the petitioner's qualification to contest the election in question. For reasons set out in the said ruling, the said paragraphs of the third respondent's reply to the petition on the qualification of the first petitioner to contest the election remain and are hereby struck out once again. The petitioners, under their aforesaid objection in Part B of the petitioner reply, submitted that the third respondent reply is incompetent because the learned senior counsel who signed the reply has no name number shown or reflected on the reply in breach of the NIMC Act. I am of the view, as held by the Supreme Court, that the same regulations do not apply to proceedings filed in this court. And this issue has been decided in a ruling by this court on the 24th of June 2019 in the second respondent's motion to amend his reply to the petition, and in the ruling just delivered on the motion filed on the 14th of May 2019 by the second respondent on the authority of the case of APC and Senator Kabir Marafa and others. Now, the filing and signing of court processes are governed by Section 2, 1, and 24 of the Legal Practitioners Act. The objection to the petitioner's prayer 1, 2, 3, 4, and 5 of Part B of the third respondent's petition is therefore lacking in merit and it fails. In respect of paragraph 5 to 21 of the petitioner's reply to the third respondent's reply under Part B, pages 5 to 11 of the reply, it is necessary to compare the paragraphs with paragraph 16(1)(a) of the first schedule to the Act in order to determine if in fact they contravene the said paragraph of the first schedule. In my view, it is my view that paragraph 5, 6, 7, 8, 9, and 11 of the said paragraph of this petitioner's reply to the third respondent's reply, Part B, are within the contemplation of paragraph 16(1)(a) of the first schedule to the Electoral Act, as they were necessitated by new issues of fact raised by the third respondent in the reply to the petition. However, a close perusal of paragraphs 10, 12, 13, 14, 16, 17, 18, 19, 20, and 21 of the reply, they are clearly outside the precinct and contemplation of paragraph 16(a), 1A and B of the first schedule to the Act. But they are in gross violation of the said paragraph of the first schedule to the Act. The paragraphs 10, 12, 13, 14, 15, 16, 17, 18, 20 to 21 of the petitioner reply tantamount to bringing in new issues, new grounds, and prayers tending to amend or add to the contents of the petition. These paragraphs for violation of paragraph 16(1)(a) and B of the first schedule to the Electoral Act are liable to be and are hereby struck out. At the same time, all the paragraphs of the witness statement on oath filed together with the petitioner's reply to the third respondent's reply to the petition are consequently struck out insofar as they touch on the paragraphs which were struck out in Part B, which have not been struck out for being in contravention and breach of paragraph 16, subparagraph 1, A and B of the first schedule thereof. My learned brother to my immediate right will pronounce his decision in respect of this motion.
I agree.
My learned brother to my immediate left will say his decision in respect of this motion.
I agree.
My learned brother to my extreme right will now say his decision in respect of this motion. I agree. And my learned brother to my extreme left will also pronounce his own decision in respect of this motion.
I agree.
Gentlemen, at this juncture, we will take a very short break to refresh and then come back. The break will be very short.
But keep this one for office. Hold this one. I'll carry all of it. Come back with this. This one will be.
Where is this? Take this one. Of the Federal Republic of Nigeria 1999 as amended, stipulating the qualification for election to the office of President, as well as the known antecedents and pedigree of the second respondent, whether the petitioners have been able to make any case that the second respondent was not qualified to contest the presidential election held on the 23rd of February 2019, and or that he submitted false information to the first respondent in his form CF-001. 2. Considering the pleadings of the petitioners and the added evidence provided by them, whether the petitioners have not woefully failed to prove any of the allegations of non-compliance with the provisions of the Electoral Act 2010 as amended, corrupt practices, and that the second respondent was not duly elected by majority of lawful votes cast at the presidential election on the 23rd of February 2019. Lastly, 3, considering the feeble case presented by the petitioners before this honorable court, whether the court can decree that the first petitioner was duly and validly elected as President of the Federal Republic of Nigeria at the presidential election held on the 23rd of February 2019. On his part, the learned senior counsel for the third respondent also identified 6 issues in his final address, which he says required determination in this petition. And I quote him too. 1. Whether in the circumstances of this petition, the petition is competent, and whether the paragraphs which the third respondent is objecting to are regular and valid. 2. Whether the second respondent was at the time of the election not qualified to contest the said election. 3. Whether the second respondent submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the election. 4. Whether the petitioners have proved the allegation of corrupt practice in the conduct of the election into the office of the President of the Federal Republic of Nigeria beyond reasonable doubt. 5. Whether or not the presidential election held on the 23rd of February 2019 was conducted by the first respondent in substantial compliance with the provisions of the Electoral Act 2010 as amended, the guidelines and manual for election officials 2019. And lastly, whether the second respondent was duly returned with a majority of lawful votes cast at the election into the office of the President of the Federal Republic of Nigeria held on the 23rd of February 2019. Dr. Livy Uzoku-Ezean, lead counsel for the petitioners, in the final address, raised 5 issues for determination in this petition. And they are as follows. 1. Whether the second respondent was at the time of the election not qualified to contest the election. 2. Whether the second respondent submitted to the first respondent affidavit containing false information of a fundamental nature in aid of his qualification for the said election. 3, whether from the pleading and evidence led, it was established that the second respondent was duly elected by majority of lawful votes cast at the election. 4, whether the presidential election conducted by the first respondent on the 23rd of February 2019 was invalid by reason of corrupt practices. And lastly, 5, whether the presidential election conducted by the first respondent on the 23rd of February 2019 was invalid by reason of non-compliance with the Electoral Act 2010 as amended, the Electoral Guidelines 2019, and the manual issued for the conduct of elections, end of quote. The same issues were raised in the petitioner's final written address in reply to the final address of each of the respondents to the petition. I am of the view that the issues formulated by Dr. Levi Uzo-Okwuezeyan for the petitioners represent the complaints and the grounds upon which this petition is brought and can be utilized for the determination of the petition, and the said issues will be considered in sequence and order they were argued by the learned senior counsel for the petitioners as well as the other counsel for the respondents. I went ahead to do so. There are several arguments canvassed in respect of issues 1 and 2 by all the learned senior counsel for the parties. I'll go to the resolution of the issues 1 and 2, canvassed by the parties. The petitioners have pleaded in paragraph 388 to 405 of their petition that the second respondent does not possess the requisite educational qualification to contest the presidential election conducted on the 23rd of February 2019, and that he had submitted to the first respondent an affidavit containing false information of a fundamental nature to aid in aid of his qualification for the said election. In view of the enormity of the time and energy devoted to the allegations of the parties in this petition and the submissions by the learned senior counsel, the broad spectrum provisions of the Constitution, the Electoral Act 2010 as amended, it is in the interest of justice to reel out the entire pleadings of the petitioners relating to issues 1 and 2 under consideration. And I did. I set them out. I will now have resort to the Constitution and the Electoral Act as amended on non-qualification and disqualification of the second respondent to contest the February 2019 election. The reason is that it is said that the Constitution and the Electoral Act, the reason is that it is the said Constitution and the Electoral Act that govern matters or issues relating to qualification and grounds for presentation of an election petition on the ground that a candidate is not qualified to contest a particular election. The court will be guided in the interpretation of the provisions relating to the qualification in the said Constitution and the Act by decided cases. The Supreme Court has settled that when it comes to qualification to contest an election, recourse must be had to the provisions of the Constitution of Nigeria and the Electoral Act as amended. In the case of Ucha and Onwe, decided in 2011, citation of which is set out, Tabai JSC stated, and I quote him, "It was, in addition to the petitioner's fellow respondent, also relied on Emero and Duru, 2004 9 Nigeria Equal Law Report, Part 877, page 75, and Abana and Obi, 2005 6 NWLR, Part 920, at page 1 to 3. In Emero and Duru, the case of the first respondent was that he was duly nominated by his parties, screened and cleared, and indeed contested the election of 16th April 2003, and won and was duly issued with Form EC8E1 by the returning officer. Thereafter, the second withdrawal respondent purported to cancel, withdraw, and invalidate the said Form EC8E1 and declared the appellant winner of the said election. The first respondent therefore filed a petition at the election tribunal which gave him judgment and granted the relief as follows. The appeal to the Court of Appeal was dismissed. In the concluding paragraph of the lead judgment, at page 106 of the report, Fabi JCA, as he then was, concluded. In conclusion, this appeal is devoid of merit. The appellant who did not contest an election cannot be returned. He has no seat in the House of Representatives. It is clear from the report that the petitioner actually contested the election and won. He was issued a certificate of return, and the substitution on the petition was predicated, and the substitution on which the petition was predicated was made after the election. The matter, therefore, was clearly a post-election matter over which the election tribunal had jurisdiction. In the circumstance, I hold that the authority does not support the principle postulated by the counsel for the first respondent. I've also read Abana and Obi, cited by the Learning Council, and I cannot say without any equivocation that the case has no bearing whatsoever upon the issue of proper venue for a pre-election or post-election dispute. The Learning Council for the first respondent made further reference to provisions of Section 246(1)(b)(1) of the Constitution on appeal to the Court of Appeal. His Lordship went on. And concluded that the result of both analysis is that the appeal has merit and should be and is hereby allowed. The nomination and substitution of the first respondent upon which the petition was predicated was clearly a pre-election matter over which only the Federal High Court or State High Court has jurisdiction. Then in INEC, in PDP and INEC, 2014, as I mentioned, Okoro JSC said, as I mentioned earlier, a person who wishes to challenge the election on the basis that the winner was not qualified to contest the election has an umbrage under Section 138(1)(a) of the Electoral Act. That is to say, where a person failed to take advantage of Section 31(5)(6) in the High Court, he can still approach the election tribunal under Section 138(1)(b). Nigeria, he is adjudged to be a lunatic or otherwise declared to be of unsound mind. Or D, if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or a fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed on him by any court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. E, within the period of less than 10 years before the date of the election to the office of president, he has been convicted and sentenced for an offense involving dishonesty, or he has been found guilty of the contravention of the code of conduct. Or F, is an adjudged bankrupt, having been adjudged or otherwise declared bankrupt under any law in force in Nigeria or any other country. Or G, being a person employed in the civil service or public service of the Federation or any state, he has not resigned, withdrawn, or retired from employment at least 30 days before the date of the election. Or H, he is a member of any secret society. Or J, he has presented a false certificate to the Independent National Electoral Commission. Subsection 2, where in respect of any person who has been adjudged a lunatic, declared of unsound mind, sentenced to death or imprisonment, or adjudged a declared bankrupt, any appeal against the decision is pending in any court of law in accordance with any law in force in Nigeria. Subsection 1 of this section shall not apply during the period beginning from the date when such appeal is lodged and ending on the last day when the appeal is finally determined, or, as the case may be, the appeal lapses or is abandoned, whichever is earlier. Subparagraph 3 of section 137(1) of the Constitution says, a person who was sworn in as president to complete the term for which another person was elected as president shall not be elected to such office for more than a single term. End of quote. Now, section 318(1) of the Constitution defines what the term school certificate or its equivalent mean as provided under section 31. It provides thus: school certificate or equivalent means A, a secondary school certificate or its equivalent, or grade 2 teacher certificate, the city and guild certificate, or B, education up to secondary school certificate level, or C, primary 6 school leaving certificate or its equivalent. I, or that should be Roman 1, service in the public service, in the public or private sector, in the Federation in any capacity acceptable to Independent National Electoral Commission for a minimum of 10 years. And 2, attendance at courses and training in such institutions as may be acceptable to the Independent National Electoral Commission for periods totaling up to a minimum of 1 year. And 3, the ability to read, write, understand, and communicate in English language to the satisfaction of the Independent National Electoral Commission. And D, any other qualification acceptable by the Independent National Electoral Commission. End of quote. The petitioners have argued strenuously that failure by the second respondent to attach the certificate listed in Form CF001 to this form means that the second respondent does not possess the certificate he claimed in Part C of the said form about the schools attended or the educational qualification with dates, and that evidence of all educational qualification should be attached. The second respondent stated in the said column that he attended primary school and has primary school certificate in 1952, that he has secondary education and was in 1961 for his higher school. He stated officer cadet 1963. There is no evidence before this court to show or prove that the secondary respondent lied that he went to the primary school, secondary school, or that he joined the army in 1962 with RW1 and many other persons in the second respondent's CV attached to Exhibit 1, which was the form FCF001 attached to the second respondent name, which was submitted to the first respondent. The Exhibit P1 tendered by the petitioners at page 1 thereof shows conclusively that the second respondent attended primary school and that he attended Katsina Provincial School. Petitioners have also relied on Section 76 and 31(4) of the Electoral Act 2010 as amended, and that it is compulsory for the second respondent to attach evidence of qualification to Exhibit 1. Section 31(4) of the Electoral Act provides, and I quote, "Any person may apply to the Commission for a copy of nomination form, affidavit, and any other document submitted by a candidate at an election, and the Commission shall, upon payment of a fee prescribed, issue such a person with a certified copy of the document within 14 days. The above section of the Electoral Act does not say in any way that a document or school certificate or certificate of qualification be attached to the said form. In any event, Section 31(4) of the Electoral Act must be read together with Section 31(2) of the same Act, which says, I quote, "The list or information submitted by each candidate shall be accompanied by an affidavit sworn to by the candidate at the Federal High Court or High Court of the State or Federal Capital Territory, indicating that he has fulfilled all the constitutional requirements for the election to that office. The reasonable inference and plausible meaning attachable to the above provision of the Electoral Act as amended is that a candidate can list information concerning evidence of his qualification or other relevant information about him. The demand or information required in Exhibit 1 cannot be more or higher than the statutory requirement." Section 76 of the Electoral Act, as amended, provides, "The forms to be used for the conduct of election under this Act shall be determined by the Commission." Where the provisions of the statute is straightforward and unambiguous, the court cannot read anything into the statute what it does not contain. A statute must be succinctly read, must be solidly interpreted in a manner that will project and bring out succinctly the real intention of the lawmakers. No extraneous matter should be allowed to stray into the principle of interpretation of an act or the Constitution. The cases referred to, in my view, the provisions of Section 76 of the Electoral Act is clearly inapplicable to the issues under consideration. The form referred to in the said section are the form to be used in the conduct of an election as the from Exhibit A has been taken care of in Section 31 of the Electoral Act, and the said exhibit is tied to the steps laid down in the said section 31 of the Electoral Act. More importantly, the law is firmly settled that the candidate is not required by the Constitution or the Act to attach his certificate to Form CF001 before the candidate can be considered or adjudged to have the requisite educational qualification to contest the election. For instance, in the case of Kaki and PDP, decided in 2014, citation of which is set out, Galadima JSC has stated that the contention of the appellant that the fourth respondent was not qualified to contest the election because of non-presentation of his certificate. However, the court below recognized the fact that the issue of non-qualification of the fourth respondent by virtue of non-presentation of his certificate was never the case of the appellant from the beginning, as earlier observed. The appellant has contended that, having regard to sections 182(7)J of the Constitution, the fourth respondent is necessarily required to present his certificate to the first and second respondent in order to prove his qualification to contest the election. Otherwise, he is disqualified under section 177D of the Constitution. And that by section 167D of the Evidence Act, the failure is fatal because if produced, it would have been unfavorable to him. This contention is misconceived. Submission or presentation of a certificate is not the requirement of section 177D of the Constitution as regards the gubernatorial screening process. The process of screening with the appellant and the fourth respondent undertook with the first respondent requires that the candidates to fill in his qualification in the form and to swear to a verifying affidavit that the information contained in Form CF001 was true. This takes away the necessity of presentation of actual certificate to the first and second respondent. When the appellant was confronted under cross-examination with exhibits C and D, the nomination form, which is similar in form with INEC Form CF001, and with the first respondent used in screening the appellant and the fourth respondent, he stated that he did not attach his certificate to his party nomination form, and that he did attach his certificate to his primary nomination form, party nomination form, and that the same procedure of not attaching certificates to the nomination form applied to all candidates. He admitted that presenting or submission of certificate was not a requirement for the purpose of screening. See page 1711, volume 1 of the record. In any case, his lordship continues, it is not a requirement of section 177D of the Constitution for the candidate to necessarily present the certificate to qualify for election to the office of governor of the state. By the provisions of section 177D of the Constitution, a person shall be qualified for election to the office of governor of the state if D, he has been educated up to at least school certificate level or its equivalent. By section 138(1), school certificate or its equivalent means B, educated up to secondary school certificate level. In Bio and in JIDA, 2004, 8 NWNR, Part 876, 544 at 630, 2004 FWLR, Part 192, page 10 at 78, the Court of Appeal, then the Apex and Final Court on Election Petition, Assembly/Governorship and Legislative Houses Election Tribunal, had this to say on the point, and his lordship courts the presentation or the holding by the Court of Appeal. In other words, as regards a secondary school certificate examination, it is enough, in my view, that one attended school certificate level, that is, without passing and obtaining the certificate, end of quote. His lordship continued, by the combined reading of section 177D and section 138B of the Constitution, it is not only the requirement or basis, which is not the only requirement or basis for qualification, but the candidate has been educated up to secondary school level. I am one I am on one, an agreement with the learned counsel for the respondent that it is not only by presentation of certificate of the respondent that is the only proof that the first respondent is qualified as the appellant here, who has taken his disposition and did not by his own showing under cross-examination present or submit one. As rightly held by the court below, by section 131 to 134 of the Evidence Act, it is only by cold facts presented to the law court that the civil rights and obligations of the parties are determined. By dint of these foregoing sections of the Evidence Act, learned counsel would do well for the litigants, who would be happier if they shown sentiments, as this comment no place in judicial deliberations. See Ogbiti and NAOC Limited, 2010-14 NWLR, Part 1213, page 208. A litigant must be able to establish his case on the evidence he presented before the court or on known and settled principles of law. In sum, the appellant having failed to show that the concurrent findings of fact by the lower court is perverse, thereby occasioning miscarriage of justice, I cannot disturb the same, and the conclusion that the appellant's claim is frivolous, brought malafide, vexatious. The end of quotation. See also the case of Olatunji and Wahid, decided in 2010, citation of which is set out. The provisions of the Electoral Act cannot subvert the clear provisions of section 131, 137, and 138 1D of the Constitution of Nigeria as amended. Any allegation of giving false information on affidavit submitted to INEC must be false information of a fundamental nature that breaches any of the provisions of section 131, 137, and 138 1D of the Constitution of the Federal Republic of Nigeria. The petitioners insinuated that the officer candidate is not a qualification or certificate under the Constitution or the Electoral Act. The Oxford Advanced Learners Dictionary of International Students Edition, 7th edition, described cadet as a young person who is training to become an officer in the police or the armed forces. There is evidence on record by LW2 and LW3, 4, and 5 that the second respondent has secondary school education at Katsina Provincial Secondary School, now Government College Katsina, from where he proceeded to Nigerian Military School, Kaduna, from Form 6 in 1962, along with RW1. In effect, the second respondent went through education in the military after his secondary school education. The military training is though higher than secondary school certificate education. The petitioners in paragraph 3.43 in the address, 3.43 in the address, in response to INEC final address, submitted that the second respondent gave false information, which he claimed in his affidavit deposed to on the 24th of November 2014, and submitted to the first respondent via from CF001 on the 18th of October 2018, when he said all his academic qualification documents as filed by him in the presidential form were with the Secretary Military Board as at the time he made the affidavit. The petitioners also said that they have proof that the false affidavit, they have proved false affidavit, and in addition, they pleaded and tendered public statement by the Secretary to the Army Board, both in electronic and print media, and also relied on P80 and P24 to show that the Army emphatically denied the claim, and as such, the onus of proof has shifted to the second respondent to disprove the claim. The fact remains that the second respondent did not call the Director of Army Public Relations, Brigadier General Olajide Olaleye, who they pleaded in paragraph 396 of the petition as having debunked the assertion of the second respondent in the affidavit sworn to on the 24th of November 2014. The said paragraph 396 constitutes the fountain and pivot of the petitioner's allegation and they have the duty to show that the affidavit contained false information of a fundamental nature in aid of his qualification for the election. What the petitioners did through P24 and no witness to cross-examine on it, thereby rendering this exhibits of no probative value, as the court cannot rely on them at the fountain and found in favor of the petitioners. The consistent holding of the Apex Court is that such documents must be tendered through their makers, or where tendered from the bar, the maker or a witness with knowledge of the exhibits must be called to give evidence on them. More so, the petitioners made allegations of crime the cornerstone of issues 1 and 2 in this petition. In the case of Pezu and Oti, 2016, citation of which we set out, Galadima again once said, "It is set in law that a party who did not make a document is not competent to give any evidence on it. This is the situation where PW19 did not make exhibit PWC2. She cannot competently tender it. The maker must be called to testify to credibility and veracity." See also the case of Wike, Yesem, and Peterside, the case of Emmanuel and Umana. But that is not the end of the matter. The matter goes further. And even if exhibits 24 and 80 are admissible exhibits which can be used in this petition, PW can be used, can be recorded probative value and weight. The newspaper in exhibit P22, P24, and in particular, the statement or refutation by Brigadier General Olajide Olale on the 21st of January 2015 does not at all support the position of the petitioners that the second respondent has no certificate, or that he was not educated up to secondary school certificate level, as the exhibit is point blank on this issue. The exhibit P24 point blanks confirms that the second respondent obtained a WASC certificate, otherwise known as West African School Certificate, and that he attended the schools listed in exhibit P1. I will reproduce in full the statement of the Army made under the title "Army Speaks on Buhari Certificates" by one Kingsley Omonobi. The whole report, the complete report, reads, and I quote, "Abuja, as controversy continues to trail the academic qualifications of the presidential candidate of All Progressive Congress, APC, Major General Muhammadu Buhari, the Army yesterday said it was not in possession of Buhari's credential. The APC presidential candidate, Major General Buhari, had averred in an affidavit he deposed before an Abuja High Court that all his certificates were with the Secretary Military Board while submitting his Form 199A to the independent, is from CF001 to the Independent National Electoral Commission, INEC. But the Army yesterday denied being in possession of the APC's candidate's original certificate or the certified true copies. The outgoing Director of Army Public Relations, Brigadier General Olajide Laliye, who addressed newsmen in Abuja, said, and he quotes, "The Nigerian Army does not have the original copy of his, Buhari in bracket, West African Certificate Council, WAEC result, or a certified true copy," end of quote. The report continues, but the APC, in a swift reaction, has warned that those who are bent on destroying Buhari on the basis of his certificates may end up destroying the country's military. The Army spokesman, who told newsmen that the Army had that the army had and which he displayed were information contained in the forms Buhari filed at the point of his entry into the military and some letters of recommendation by a principal of the Provincial Secondary School, Katsina. For the record, Olajide said, records available indicate that Major General Muhammadu Buhari applied to join the military as a Form 6 student of the Provincial Secondary School, Katsina, on October 18, 1961. His application was duly endorsed by the principal of the school, who wrote a report on him and recommended him as suitable for military commission. The report, which was shown to newsmen, read, and there's a quotation in quote, "I recommend Muhammadu Buhari fit for military commission," end of quote. On Buhari's result, the principal also wrote, and I quote again, quote in quote, "I considered that he will pass math, English, and 3 other subjects," end of quote. Laleye said the briefing was necessitated by the deluge of requests from civil society groups and the media, among others, over General Buhari's ineligibility for any political office. He continued, he said, "It is a practice in the Nigerian army that before candidates are shortlisted for commissioning into the officers' cadre of the service, the selection board verifies the original copies of credentials that are presented. However, there is no available record to show that this process was followed in the 1960s. Nevertheless, entries on the Nigerian Army Form 199A at the point of documentation after commission of an officer indicated that the former head of state obtained the West African School Certificate, WASC, in 1961 with credit in relevant subjects: English language, geography, history, health science, Hausa, and a pass in English literature." Laleye continued, "Neither the original copy, certified true copy, CTC, no statement of result of Major General Muhammadu Buhari's WASC result is in his personal file. What I have said here is what is contained in his service record personal file. We have not added or subtracted anything." Earlier, Brigadier General Laleye has said, "Let me state clearly that the Nigerian Army holds the retired senior officer in very high esteem and respect and will not be a party to any controversy surrounding his eligibility for any political office. Suffice it to state that Major General Buhari rose steadily to the enviable rank of Major General before becoming the head of state of our dear country in December 1983, end of quote. This statement apparently, clearly, unequivocally confirms that the second respondent actually obtained West African School Certificate and passed credit in 5 in 1961 in English language, geography, history, health science, Hausa. The statement confirmed the truism and authenticity of exhibits R19, R20, 21, R22, and R23 tendered by the second respondent through witnesses RW3, RW4, and RW5. What Brigadier General Olajide Laleye said is that the original copy or the CTC or a copy is not in his personal file. This does not exclude the inference that the Army may have the certificate, having regard to the fact he stated, which I again repeat. Nevertheless, the entry made on the Nigerian Army Form 199A at the point of documentation after commissioning of an officer indicated that the former head of state obtained the West African School Certificate, WASC, in 1961 with credit in relevant subjects: English, language, geography, history, health science, Hausa, and a pass in English literature, end of quote. Curiosity and common sense will ask the question: if indeed the second respondent did not present his certificate to the Army when he was commissioned as an officer, where did the Army get the record in the Form 199A in his record that he had presented, that in Form 199A, which presented records of credit obtained by the second respondent in the WASC examination in 1961? The plausible and only reasonable inference is that the second respondent presented his certificate, WASC certificate, upon joining the Army, from which the Army extracted the information in the Form 199A to show that the second respondent indeed has secured education up to school certificate level and in fact possessed the WASC certificate in 1961. Section 167 of the Evidence Act 2011 says, the court may presume the existence of any fact which it deems likely to have happened, with regard being had to common cause of natural events, human conduct, and public or private witness in their relationship to the facts of the particular case. It will be incredible and even repugnant to common sense and justice to hold, on the face of the evidence produced by the petitioner themselves in Exhibit P24, that the second respondent does not possess qualification to contest the office of the President of the Federal Republic of Nigeria as prescribed by Section 131 and defined in Section 318 of the Constitution, or that he has submitted an affidavit to the first respondent containing false information, fundamental in nature or in aid of his qualification. If the Army admits and confesses in the above statement that it has a record which indicates that the second respondent has obtained a WASC certificate in 1961 and even stated the grades he scored in particular subjects, where then lies the falsity of the information deposed to and submitted to first respondent in support of his qualification for the contest for the election of 23rd February 2019. The petitioners also tendered the CV of the second respondent, showing his educational background, military service, public service, becoming ultimately the head of state and commander-in-chief of Nigeria, commander-in-chief of the armed forces of Nigeria from December 1983 to 85. All of this were confirmed by Brigadier General Olajide Olaleye, who said the second respondent rose steadily in his career to become the head of state of Nigeria. In my view, the CV contains impressive credentials to enable the second respondent contest and hold the office of the President of the Federal Republic of Nigeria, even if it could be said that he has only a primary school certificate, which is not the case here. The second respondent has more than secondary school certificate, having attended courses, evidence of which have been attached to his Form CF001. There is no doubt that the second respondent is not only qualified, but is also eminently qualified to contest the February 23rd presidential election from the evidence presented by the petitioners themselves, as stated out above. The petitioners cannot run away from the facts that are favorable to the second respondent, particularly in exhibits P1 and P24 tendered by them. stated therein contained are not to his personal knowledge or from his personal knowledge. In effect, Exhibit P30 are also of no probative value. The allegation that the school were not in existence and there was no certificate have now been debunked by the petitioners themselves, and so they have failed to discharge the honors placed on them to prove the allegation of non-qualification or submission of an information which contains an information that is false, which is fundamental in aid to the second respondent's qualification to contest the election. In the case of Maku and Al Makura, decided in 2016, citation of which is set out, MD Muhammad JSC has said, lastly, the essence of front-loading statement of witnesses is to facilitate speedy disposal of election petition and does not justify dumping of exhibits, and urging the tribunal and the court to proceed in a manner that opens them to unnecessary and avoidable suspicion of bias. All facts that entitle the party to the court's indulgence must be demonstrated in the open court to ensure that in arriving at the decision on the matter, the court is detached and neutral, as anyone could easily see. The examination of exhibits outside the court and behind the litigant certainly stands in the way of these necessary and laudable traits. See Obasi Brothers Limited, MBA Securities, Supra, and Oilo and Akibu, 1982, 7SC, 60 and 62, and Ucha and Elechi Supra, end of quote. I also refer to the case of Ladoja and Ajimobi, which was decided also in 2016. On the failure of the first respondent to call or produce evidence, the petitioners had contended that the facts pleaded by them and by the first respondent in paragraph 98(1) of the first respondent's reply to the petition, to the effect that it was satisfied with the educational qualification presented by the second respondent, was not proved or established by the first respondent for failure to call evidence. They submitted that inasmuch as no one was called to tell the court on the alleged admissibility, acceptability on the second respondent's qualification, the learned senior counsel to the petitioner therefore submitted that paragraph 98 sub Roman 2 of the first respondent's pleading is abandoned. In his reply, the learned senior counsel submitted that there was a petition, that where a petitioner had not made out or proved his case in the petition during examination in chief, the respondent would not be called upon or required to offer evidence in defense, and that where a party has extracted evidence favorable to his case and the petitioner fails to discharge the burden on him, the respondent is not bound to call evidence. He relied on some cases, among which is Akambi and Alao, citations of which are set out. The senior counsel also submitted the petitioner's claim is declaratory in nature, and there is the heavy burden on them to prove it and not rely on either failure or default in defense by the respondents. In that case, the submission of the first respondent's learned counsel represents the law, and in that, the petitioner who alleges that the second respondent does not possess educational qualification to contest the election to the office of President of Nigeria, and they pray for declaratory relief. This much the petitioners considered in paragraph 1.01 of their final address in response to the first respondent's final address. That being the case, the onus rests squarely on them to prove the assertion that the second respondent is not educationally qualified to contest the election, or that he submitted the affidavit containing false information of a fundamental nature in aid of his qualification for the said election. This, like I've mentioned before, the petitioners have not been able to do. They cannot therefore rely on refusal or failure of the first respondent to call evidence to show how it was satisfied with the second respondent's educational qualification. I made reference to some cases. What is more, the petitioner pleaded that the second respondent who was sponsored by the third respondent, and that he contested the election. The petitioner also pleaded that he submitted this form along with some other documents which they are not challenging. This is because the second respondent went through the procedure in Section 31 of the Electoral Act and was cleared to contest the election that enables the petitioner to challenge his qualification as pleaded by them in paragraph 388 to 405 of the petition. The presumption is that the first respondent was duly cleared him to contest the election, and we made reference to some cases. The petitioners also tendered all documents compiled and submitted in Form CF-001 as Exhibit 1. The submission that INEC is deemed to have abandoned pleadings cannot therefore fall sway on whether exhibits R19 and R21 are caught by Section 83(3) of the Evidence Act. The petitioners have submitted that the said exhibits are inadmissible because they were made by a party interested when proceedings were anticipated, and in this case, after the petition had been filed and hearing commenced. In response, the Learned Senior Counsel to the respondent dealt with the issue in paragraph 423 and 425 of the reply to the petitioner's final written address. The Learned Senior Counsel to the second respondent argues that the petitioner misconstrued Section 83(3) of the Evidence Act in that exhibit R19 and 21 were actually made or produced by the West African Examination Council, WAEC, and the University of Cambridge, respectively. He also said that the documents were only obtained and not made by the correspondent, who is said to be the interested party here. The petitioners have not accused the University of Cambridge or WAEC for being persons interested, and on the meaning and scope of Section 83(3) of the Evidence Act, the Learned Senior Counsel referred to, among other cases, Kelechi and Wale, citations of which are set out. I am of the view that the second respondent is not the maker of exhibit R19 and 21, though he may be interested in them. It has not been shown or proved that the West African Examination Council and the University of Cambridge are persons or people interested in these proceedings. Whether there is variation in names of the second respondent on exhibit R19 and 21 as to whether it is Mohammed with O or Mohammed with U, the petitioner stated that the document cannot be said to belong to the second respondent because no facts were pleaded to reconcile the names. However, the Learned Counsel for the second respondent submitted that the supposed variation will not detract from the fact that the name is and could be borne by one and the same person. Learned Senior Counsel relied on the case of A.D. Afayoshi, citation of which is set out. He also relied on the evidence of RW5, who gave explanation on the names and stated they are the same. He drew an analogy from the name of lead counsel for the petitioners, whose names are Dr. Livinus Ifeanyi Uzoku Ezean, signing off processes as Dr. Livy Uzoku Ezean. The variation in name of the second respondent on exhibit R19 and 21 is non sequitur, since both of them refer to and were issued in respect of the same person who bears the names set out therein, whether Mohammed with an O or Mohammed with a U or Muhammadu. The names refer to one and the same person in respect of who the exhibits were issued, particularly since the name Buhari on the exhibit indisputably refers to and belongs to the second respondent and no other person. After all, a name is defined at page 1048 of the 8th edition of the Black's Law Dictionary to mean, I quote, a word or phrase identifying or designating a person or thing and distinguishing that person or other thing from others. From the totality of the evidence before the court, the names Mohammed Buhari with the U Mohammed Buhari, with an O, contained in Exhibit R 19 and 21, all refer to, identify, and belong to the second respondent in respect of which they were issued. I am of the view that upon all the pieces of evidence given, both oral and documentary, on the issue of qualification or on the issue of allegation of affidavit, of submission of an affidavit containing false information tendered or proffered in this case against the second respondent, there's no doubt that Exhibit R 19 and 21 relate to the second respondent. I have no doubt in my mind again that the petitioners have not proved or established that the second respondent does not possess the educational qualification to contest the election of the office of the President of the Federal Republic of Nigeria as prescribed and stipulated under sections 131, 137, and 138, 1A, B, C, Roman 1, 2, 3, and paragraph D of the Constitution of the Federal Republic of Nigeria as amended. I'm also of the firm view that the petitioners have failed to prove or show that the second respondent had submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the election as prescribed by Section 35(1) of the Evidence Act 2011 and settled by the decision of the Apex Court. Before leaving this issue, Learned Senior Counsel for the third respondent had argued what he termed subsidiary issue under the subhead non-qualification of the first respondent in his treatment of the petitioner's issues 1 and 2. All that needs to be said on the issue, all that needs to be said on the subsidiary issue and the arguments thereon go to no issue, since the paragraphs of the third respondent reply to the petition on the first petitioner's qualification to contest the election have been struck out for being incompetent by the ruling of the court on the petitioner's motion of 13th of May 2019 just delivered. As a consequence, after a review, a critical examination and evaluation of all the evidence adduced in this petition, particularly as it relates to issues 1 and 2 of the petitioners, I come to the conclusion that issues 1 and 2 of the petitioners are hereby resolved against them. I now go on to deal with issue 3, which was also canvassed by the Learned Senior Counsel for the parties. And after a consideration of all the submissions on issue 3, I resolve it as follows. Issue 3 deals with ground 15A of the petitioner's petition. And once again, it reads, the petitioner states that the grounds upon which this petition is based are as follows. A, the second respondent was not duly elected by majority of lawful votes cast at the election, end of quote. The ground is predicated on section 138(1)(c) of the Electoral Act as amended, which provides for it as a ground for presentation of a petition. The law is that where an election conducted by the National Electoral Commission, including the election in question, a return is made and a candidate is declared as elected, as in this case, then section 68(c) of the Electoral Act as amended in 2010 as amended, makes the declaration and the return made by the designated electoral body final, subject only to review by the court or tribunal as and by way of an election petition as in the present petition. Section 147, 148, 168, and 167, 168(1) of the Evidence Act 2019 presume the result of the presidential election declared by the first respondent on the 27th of February 2019 as correct, authentic, and true until proved otherwise. Because it is a rebuttable presumption, the burden is on the petitioner who claim that the results are not true, they are not correct or authentic. This position of the law has been considered in many cases, a legion of them. And I just refer to the locus classicus, Omoborio and Ajasi, citation of which is set out, where Bello JSC then, and later CJN, and also of blessed memory, stated, now, as I stated in Wobodo and Ono, Supra, there is in law a rebuttable presumption that the election result of any election declared by a returning officer is correct and authentic by virtue of Section 115, 148C, and 149(1) of the Evidence Act, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption. Where such denial is again, polling booths at the base of the pyramid, which forms the electoral process under the provisions of the Electoral Act 1982. The booths are the roots which nourish the whole electoral process. Where a petitioner challenges the correctness of the return of an election declared by the returning officer, then except in arithmetic errors in collation, the petitioner must lead evidence which would directly or indirectly establish the vote scored by him and his opponent at the polling booth. Similarly, in Buhari and INEC, decided in 2008, citation of which is also set out, Nikitobi of blessed memory has said this, and I quote him, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption. See Omoborio and Ajasi, 1984, 1 SCNR 104, Jalingo and Nyami, 1992, 3 NWLR, part 231 at page 538, Finebone and Brown, 1999, 4 NWLR, part 600 at page 613, Hashido and Goji, 2003, 15 NWLR, part 843, 352, and Buhari and Obasanjo, 2005, 13 NWLR, part 941 at page 1, end of quote. The petitioners pleaded in paragraph 16, 17, and 18 of their petition as follows, and I set them out. And in order to prove the pleadings and the assertions above, the petitioners are by law under the legal obligation to call oral or documentary evidence through witnesses who are eyewitnesses, who can give cogent and direct evidence and demonstrate before the court that there is any misapplication of votes scored by the parties at the said election. In Atiku, Raja Abubakar Atiku GCON and Umaru Musa Radua decided in 2008, which I have referred to in one of the rulings. Nikitobi again, of blessed memory, has said that a petitioner who contests the legality or lawfulness of votes cast at an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the illegality or unlawfulness. Substantially, he must call witnesses to testify that the illegality or unlawfulness substantially affected the result of the election. The documents are among those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of election, not those who picked the evidence from eyewitnesses. No, there must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of votes and the subsequent result of an election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities, both in the conduct of the election and recording of the votes. Wrongdoings and irregularities which affected substantially the result of the election. End of quote. I also made reference to some other cases on this position of the law. And the petitioner, being conscious of the onus of proof heavily placed on them by the law, have pleaded in paragraph 19 of the petition that the petitioner shall lead oral and documentary evidence at the trial to show that the results of the election as announced by the first respondent, and especially the votes credited to the second respondent, do not represent the lawful votes cast. Lawful votes were deducted from the first petitioner's scores by the first respondent in order to return the second respondent. End of quote. The petitioners have tendered from the bar from EC8As, EC8Bs, EC8Cs, EC8E, and other electoral forms or documents, particularly in respect of 13 states, including FCT Abuja, which they call the focal states. They also call, like I said before, 62 witnesses to prove the petition. The order in which the said witness testified and the states and the areas of their testimony have well been captured in the addresses of the parties. I will just reproduce some of them, and I did. The main contention or issue under this issue 3 is that the petitioners, the first respondent, has stoutly denied the existence of a server referred to and pleaded by the petitioners in their petition. The first respondent also vehemently contended that the result of the presidential election was never transmitted electronically via the smart card readers into any server belonging to INEC, and that there's no provision in the Electoral Act 2010 as amended that prescribes transmission of election results from the polling booths, polling units, polling voting points, ward level, LGA level, state, or national level. The same position was also taken by the second and third respondent. However, the senior counsel for the petitioners insisted that by the amendment of the Electoral Act in 2015, the Act number 15, which came into effect on the 26th of March 2015, Section 9 thereof amended Section 52 of the Principal Act by inserting the following new section. That's subsection 2, which provides thus: voting at an election under this Act shall be in accordance with the procedure determined by the Independent National Electoral Commission. End of quote. The Landed Silks said, to the Landed Silk for the petitioners, INEC was empowered by this provision to transmit result of election from polling units via smart card readers direct to INEC server by presiding officers or assistant presiding officers. He also submitted that it was as a result of the amendment that INEC made or issued the Manual on Election Technologies, Use, Troubleshooting and Maintenance 2019, which is put in evidence as XBP 33, Regulations and Guidelines for Conduct of Elections, XBP 27, and 3, Manual for Election Official 2019, which was put in evidence as XBP 28. Learned Senior Counsel for the petitioner strongly submitted that the combination of the above exhibits, P27, P28, and P33, constitute the authority and power of INEC under Section 52(2) of the Electoral Act as amended to transmit result of the presidential election from the polling units electronically into INEC server, and that it was the result uploaded into that server through the process he mentioned that gave the first petitioner an edge over the second respondent, relying on the pieces of evidence by PW3, PW4, PW16, PW17, PW36, PW59, and PW60. The issue here is, can it really be said that Section 52(2) of the Electoral Act as amended actually empowered or authorized INEC to electronically transmit the result of the election from all the polling booths across the nation via a smart card reader? The law is settled that if the words of the statute are unambiguous, they must be followed and interpreted in such a manner that would best bring out the manifest intention of the lawmaker. The bottom line is that it is the duty of the court to interpret provisions of a statute in order to ascertain the intention of the legislator and give effect to it. If there is any lacuna or imperfection in the law or statute, it is not the function of the court has no power to amend the law. It is in the domain of the legislature. And I refer to some cases on this. I have read the entire provisions of Section 52 of the Electoral Act as amended, and which I also set out. And I say that in the exercise of the power vested in it by the provision in subsection 2 above, the first respondent INEC made and issued Exhibit P27, which is Regulation and Guidelines for the Conduct of Elections, and Exhibit P28, the Manual for Election Officials 2019, for the purpose of the procedure to be adopted and used for the conduct of the 2019 elections. In paragraph 8A of Exhibit P27, dealing with accreditation and voting procedure at election, it is provided as follows, and I quote, "Voting shall be in accordance with the continuous accreditation and voting system, CAVS, procedures as specified in these regulations and guidelines, the election manual, and any other guide issued by the Commission," end of quote. Then in paragraph 10A, it is provided that, and I quote, "In accordance with Section 49(2) of the Electoral Act, a person intending to vote shall be verified to be the same person on the register of voters by use of the smart card reader, SCR, in the manner prescribed in these regulations and guidelines," end of quote. Elaborate procedure was then set out in paragraph 10C to F for accreditation and in paragraph 11A for voting at an election. At the end of voting, or at the close of voting, paragraph 22A, B, and C of Exhibit 27 provides the procedure for the collation, counting, recording, announcement/declaration, and transmission of the result of the election from the polling units or voting points to the registration area or ward level. These provisions are thus, and I quote them. 22A, at the close of voting, the presiding officer shall A, cancel all the unused ballot papers by crossing. 2, sort out the ballot papers by party, and thereafter loudly count the votes scored by each political party in the presence of the polling agents and observers. 3. Allow recounts of votes on demand by a polling agent, provided that such a recount shall only be allowed once. 4. Cross-check the scores. 5. Enter the scores of the candidates in both figures and words in the appropriate forms EC8A/EC8A VP in bracket series. And 6. Fill the form EC60E and paste it conspicuously. Pasting the form EC60E is mandatory, and failure to do so may amount to dereliction of duty. B. Where voting points have been created, the APO1 shall Roman 1 enter the result on form EC8A VP in bracket, and 2 submit to the presiding officer, who shall consolidate the result using form EC8A and attach the form EC8A VP in bracket to form EC8A. C. The presiding officer shall then sign, date, and stamp the appropriate forms EC8A forms. 2. Announce loudly the votes scored by each political party. Roman 3. Request the candidate or their polling agents, where available at the polling unit, to countersign. And then 4. Refusal of any candidate or polling agent to countersign the appropriate form EC8A series shall not invalidate the result of the polling unit. Keep the originals of the form EC8 series and the first pink copies for the commission. 6. Give to the polling agents and police a duplicate copy of each of the completed forms. 7. Post the completed publication results poster form EC60E at the polling unit. Complete the form EC40H1 for PWD information and statistics. Complete the PWD information boxes in PU booklet. Transmit the result as prescribed in the Electoral Act. Take the card reader and the original copy of each of the forms in temper evidence envelope to the registration area ward coalition officer in the company of security agents. And lastly, 12, the polling agent may accompany the presiding officer to the RA/ward coalition center. Then paragraph 27, Roman 7, paragraph 28B, Roman 1 to 14, paragraph 30, paragraph 31, and paragraph 32 of Exhibit P27 provide for the procedure for the collation and transmission of election results from the ward to the national level in respect of the presidential election. The procedure elaborately set out in the above paragraphs of Exhibit P27 are repeated in Chapter 3, Paragraph 3.1a, Roman 7, Paragraph B, C, D, and E of Exhibit P28. At page 68 of Exhibit P28, the title, quote, Election Collation Flow Charts, Presidential, end of quote, was provided, clearly demonstrating the procedure provided for in the aforementioned paragraphs. As can be clearly seen, it is undeniable that the procedure for collation and transmission of election results in the above paragraphs of Exhibit P27 and P28 is manual by election officials at different and all levels or stages of an election, from the polling units, voting points, which are the foundation for every election conducted under the Electoral Act, to the final stage for the purpose, for our own purpose here, the national level. There's no provision in either Exhibit P27 or P28 for transmission of election result electronically, either by the use of smart card reader or other means at any level of an election. In addition, there is no provision in the amended Electoral Act authorizing or empowering the first respondent or any of its officers, including presiding officers 1, 2, and 3, mentioned in Exhibit P 27 and 28, the regulations the regulation and guidelines for conduct of election, and the manual for election officials 2018, which allow transmission of election result electronically to any server through the use or by use of a smart card reader. There's also nothing, even in Exhibit P27 and 28, empowering or authorizing election officials of the first respondent to use the smart card reader for electronic collation and transmission of the results. The reliance placed on Exhibit P33, Manual on Election Technologies, pages 15 to 32 thereof, is misplaced because there's no evidence before the court that the said Exhibit P33 was deployed for use in the 2019 elections. Exhibit P85, which was a video tendered through PW40, points to the contrary. The first respondent's chairman had in the said exhibit informed the public that due to logistics problem, transmission of election results by electronic transmission was not feasible or attainable. Exhibit P27 and P28 show that the results of the election were to be manually collated, entered into various appropriate forms by the election officials manually, and results announced publicly at every stage of the electoral process. The evidence of PW62, the star witness for the petitioners, veers and supports the position and the fact that there was no electronic voting and results were not transmitted electronically, even during the collation and announcement of the presidential election at the national level by the first respondent's chairman. The evidence of PW2, PW4, PW16, PW17, and PW36, which are invariably in respect of only 5 polling units, did not establish that there was electronic transmission of results of the election in the entire polling booths and polling voting points in the country by the use of smart card reader. These witnesses, in addition, have said that under cross-examination, informed the court that they did not know the identity or the particulars of the alleged INEC server into which they allegedly transmitted results of the election. Some of them even gave evidence that INEC gave them the code to transmit the result electronically. But when asked the PIN number of the code, some of them stated that they could not disclose the code, while others said they could not remember. The pieces of evidence given by the said 5 witnesses does not have any bearing or impact on the proof required of the petitioners. It is like a drop in an ocean. Their evidence, either alone or together, have failed to establish the claim that of the petitioners on the issue of electronic transmission of results. In effect, the petitioners have not proved this aspect of their case. I'm not unmindful of the submission of the Landed Senior Counsel to the petitioners, who, while relying on Section 153 of the Electoral Act as amended, stated in the written address, which I set out, and I'll read, paragraph 4.24. It is pursuant to the above provision that the first respondent prescribed elaborate procedure for electronic collation and electronic transmission of results for the 2019 election. It is clear that the first respondent, under the heading Accreditation and Voting, procedure at election in its 2019 election guidelines P27 made elaborate provisions on use of voters register and card readers in the accreditation of voters and voting procedure. See paragraphs 8, 10, 11, 12, and 13 of Exhibit P27. It is noteworthy that the scope covered by the above procedure is wider than the guidelines for the 2015 general elections. See also paragraph 23 to 28 of the Manual for Election Official 2019, Exhibit P28. Like I said before, I have carefully examined and re-examined Exhibit P27, and there's nothing again contained on electronic collation and electronic transmission of votes results for the 2019 general election, particularly in the presidential election conducted on the 23rd of February 2019. It is also the contention of the petitioners that the scope of exhibit covered by Exhibit P20 is wider in scope than the guidelines of 2015 general election. The Exhibit P27 does not, with respect, support the submission of the learned senior counsel. Contrary to that submission, contrary to submission on Section 52(2) of the Electoral Act, that it now gives backing to the first respondent to transmit result of election electronically via the smart card reader. There is no such statutory backing as has been demonstrated above before now. The position on the use of smart card reader in election has not changed since 2015, for the simple reason that the court, the electoral law outlawed the use of electronic voting. It is stipulated to have been prohibited. However, even if there is no electronic voting, there is no provision of the Electoral Act, as I mentioned before, which provides for the collation and transmission of election results at all levels of an election in Nigeria. The controversies engendered and generated by the use or non-use of the smart card reader in the 2015 election, and whether the card reader report can be used to determine the actual votes or results in an election, including the presidential election, have been considered by the Supreme Court in a number of cases. And the Supreme Court has settled the law on the position of the use of the card reader in an election, and interpret Safi and Yari Supra, Okereke and Umahi, unreported SC 1004/2015, delivered on the 5th of February 2015, at pages 31 to 34, end of quote. And is at pages 525A to H, The Lordship continued and said, as I stated earlier in this judgment, that INEC is to be commended for the innovation of the card reader machine to boost transparency and accuracy for the accreditation process and to maintain the democratic norm of one man, one vote by preventing multi-voting by a voter. Nonetheless, Section 41, Sub 1 and 2 of the Electoral Act 2010, as amended, which provided for manual accreditation of voters, is extant and remains a vital part of our electoral law. The section provides thus: any person intending to vote with his voter's card shall present himself to a presiding officer at the polling unit in the constituency in which his name is registered and with his voter's card. 2. The presiding officer shall, on being satisfied that the name of the person is on the register of voters, issue him with a ballot paper and indicate on the register that the person has voted. In the recent decision of this court in Shinkafi and Yari, 2016, 7 NWLR 1511, part 1511, page 340, Okoro JSC stated thus: my understanding of the function of the card reader machine is to authenticate the owner of a voter's card and to prevent multi-voting by a voter. I'm not aware that the card reader machine has replaced the voter's register or has taken the place of statement of results in appropriate forms. End of quote. Again, our Lordship continued, Nweze JSC, Kereke and Umahi and others, all reported SC 1004/2015, delivered on the 5th of February 2016, reiterated the position thus at page 30, whose juridical roots are firmly accreditation. In order to prove non-accreditation or overvoting, the first respondents were bound to rely on the voters' register in all the affected local governments. The voter registers tendered were in respect of only 11 out of the 23 local governments. They were tendered from the bar as Exhibit A 207 to 281. No attempt was made to link them with Exhibit A9. It is also noteworthy that forms EC8A were tendered in respect of only 15 out of the 23 local government areas. An attempt was made to confront some of the defense witnesses with the forms EC8A to show that the number of votes credited, number of voters credited, stated therein was in conflict with the number of accredited voters as per Exhibit A9. In any event, as rightly submitted by the Learning Council for the appellant, the tendering of Exhibit A9, A10, A12, A31, A32, A270, A271 to A281, A282 to A380, 300, A301, A303 to A307, B30, and B1 from the bar, without their makers being called, amounted to documentary hearsay, and the tribunal and the lower court were wrong in placing reliance on them. I am of the view, and I do hold, that the tribunal and the lower court were unduly swayed by the INEC directives on the use of the smart card reader. As held by this court, the INEC directives, guidelines, and manual cannot be elevated above the provisions of the Electoral Act so as to eliminate manual accreditation of voters in an election. This will remain so until INEC takes steps to have the necessary amendment made to bring the use of the card reader within the ambit of the substantive Electoral Act. I also refer to some other cases and pronouncement by the Supreme Court. Now, PW 59 was specifically called to establish the existence of an INEC server and to show that the result imputed into the alleged server through the smart card reader, the petitioners proved all the irregularities contained in all the 35 states of the Federation and FCT, except Rivers State, as pleaded in paragraph 16 to 106 of the petition. Reliance was placed on exhibits 87, P87 to P88, and P89. The petitioners also relied on what they described as analysis of votes. The results obtained as reflected in the certified 2 copies of Form EC8A, EC8B, and EC8E from 11 focal states, namely Kaduna, Katsina, Kebbi, Kano, Borno, Gombe, Jigawa, Niger, Yobe, and Zamfara states are pleaded in paragraph 113 to 363 of the petition. And they called PW6, who is referred to as a statistician and an expert, whose reports were admitted in evidence as XBP 90 A to K in respect of the 11 aforesaid states. PW 59 testified on the 19th of July when he adopted his statement on oath, and his evidence revealed that his report is based on a website whose owner he does not know. The website is www.factsdon'tlie.com, factsdon'tlieng.com, according to PW 59, and that the author of the website relied upon by him had claimed to be a former INEC staff. The website, according to PW 59, was created on the 12th of March 2019, about 2 weeks after the result of the presidential election was announced. On page 6 of Exhibit A, attached to his witness statement on oath, PW 59 said he copied into page 6 INEC's diagram for training manual, and concluded on page 6 of Exhibit 8, attached to his written statement on oath, as follows. I will quote him. Whistleblowers Data Analysis Fact Don't Lie website, www.factsdon'tlieng.com. The website was created on the 12th of March 2019. A look at the website will show that apart from the information on INEC records, nothing else appeared there. It has no other basic information or navigation features as to what a regular website ought to contain as a contact, about, etc. The author of the content of the website revealing the information on INEC server claimed to be an INEC staff. He remained anonymous and hence Christian whistleblower. In paragraph 18 and 19 of his witness statement of oath, he concluded as follows: bearing a simplified and common understanding of the server and quotation and a computer, a device or a program that is dedicated. I'll take that again. A, bearing a simplified and common understanding of a server or a computer is a device or a program that is dedicated to managing networks, resources such as storage, communication, security, centralized applications, and database management system, and acknowledging the INEC guidelines which outline a transparent and integrated electronic process of voters' accreditation, vote collation, and transmission. Indeed, there existed a robust system of servers whose extensive use in the presidential election is undeniable. B, the analysis of data held at the whistleblower website using standard professional data analysis tool and techniques authoritatively demonstrate accuracy and precision, legitimacy and validity, reliability and consistency, timeliness and relevance, completeness and comprehensiveness, granularity and uniqueness of the database, of the data whose base can be nothing but INEC servers. C, an expertise, corroboration, and correlation of the technical processes, data, and description of whistleblowers' data hearing and the INEC setup is an explicit and implicit demonstration that the server from whose data the whistleblower was drawn is INEC tallying server. 19, that a report in my findings are attached and marked as Exhibit 8. Its evidence is that it is the whistleblower's data analysis, Facts Don't Lie website, www.factsdon'tlieng.com, that his report is based on. He variously referred to the owner of the website as a whistleblower, as anonymous, or the author of the content of the website claimed to be an INEC staff. PW59, as could be seen in his evidence, did not rely on any data gotten by him from INEC server. He stated that the server he relied upon for his report as an expert was an anonymous website, which to me is doubtful, unreliable on any account for any information that would be relied on by an expert who is truly an expert. PW59 gave his evidence and report, and the report he authored. Whatever results he claimed to have gotten, according to him, came from the server belonging to a whistleblower and not INEC. When asked under cross-examination the source of the results he claimed were found in the anonymous website, PW59 said the author of the content of the website may be an INEC staff, but that the anonymous author of the content of the website got the information or the result from INEC servers, which he said he could not access without the consent of INEC. Under further cross-examination, he admitted that the information in the website whistleblowers data analysis Facts Don't Lie website, www.factsdon'tlieng.com, could have been doctored. Under further cross-examination by the line senior counsel for the third respondent, PW59 said, as an expert, it is possible to use scientific method to decrypt data source and tamper or alter the content information contained therein. PW59's report and evidence is thus hanging on the third-party information from an undisclosed source. The evidence of PW59 is no doubt caught by Section 37 of the Evidence Act, which provides, and I quote, hearsay means a statement, oral or written made otherwise than by a witness in the proceedings, or B, contained or recorded in a book or a document or any record whatever, proof of which is not admissible under any provision of this Act, which is tendered in evidence for the purpose of proving the truth of the matter stated therein. I underline some portions. End of quote. As can be seen from the evidence of PW59, you cannot, by any stretch of imagination, be classified as an expert opinion, as it is not supported by any direct knowledge of what his report contained. It is with regard contained, and it is not supported by anything he did directly with regard to the existence or otherwise of an INEC server, which he now claimed to have gotten the information from. He relied on the third-party information drawn or prepared or given to him or through the whistleblower, an anonymous source, an incredible and unverifiable source, which is not derived from his own personal knowledge. Worse still, his informant, the author of the content of the website relied upon by him, cannot be identified. Even if he could be identified, it is the alleged whistleblower or the anonymous author who claimed to be INEC staff or who was a former INEC staff that could give evidence of anything relating to the existence of the alleged server, from which the evidence was not challenged under cross-examination. In the petitioner's final address, in reply to the first respondent's final address, in paragraph 5.02, 0.03, 5.17, and 5.18 thereof, the learned senior counsel said thus, and I quoted him. PW61 is a collation agent of the petitioners in Kogi State. He is one Captain Joe Agada, retired. Under cross-examination, he said that he voted in a polling unit at Olaboro Unit 18, that in some cases, disturbances started before election. He also visited 4 polling units on the day of election, and there are 2,300 polling units in the state. He visited only 4 polling units where, he said, was perpetrated. This was under cross-examination by the learned senior counsel for the first respondent. Among other things, that he was duly accredited before he voted, and that the card reader was used for his accreditation. He did not have the Form 40G. He did not have the Form 48 to evidence the recording of any violence. He did not sign, and he did not sign the form, and he refused to collect the result after the election. He did not have the voters register in respect of the places complained of about the complaints in respect of the state which he represented the petitioners. They have dealt with the evidence of PW60, whose evidence is also hearsay, in respect of the copies of the forms EC8Cs, EC8Bs, and EC8C deployed in 11 states, in respect of which he was engaged to examine. The evidence of PW62, the star witnesses once again, covers virtually all the facts pleaded in the petition. Under cross-examination by all the learned counsel for the respondent, he left no one in doubt that he had no personal knowledge of all that happened at the various polling units across the country, whereas the petitioners based their allegation in paragraphs 107 to 387 of the petition. I've mentioned it. He stated that he was at the situation room of the PDP on election day, and the information contained in his witness statement on oath about wrongdoings at polling units, ward levels, local government level, state level across Nigeria were gathered from third parties who were their agents in the said level of the coalition of the election process. He was therefore not an eyewitness to any incident except the one that happened at the National Coalition Center, where he was the National Coalition agent for the petitioners. He told the court that the coalition was done all over the country, including the national level, manually. PW62's evidence cannot in the least at all command any value on the quantum of pieces of evidence given by him, and do not establish the horrendous allegations on commission of crimes and criminal allegations contained in the paragraphs of the petition. He cannot be in the situation room in his party's office and be at the polling units in all the polling stations or polling units and voting points in Nigeria. The petitioners under ground 2 of the petition dealing with non-compliance with the provisions of the Electoral Act as amended pleaded in the paragraphs of the petition which I've mentioned that there was overvoting in so many polling units. For example, in paragraph 1153, the petitioners avert thus, and I quote, overvoting. The petitioners shall contend that out of 1,941 polling units in the affected 26 local government areas in the state, the first respondent in respect of the 490 polling unit reflected results showing that the number of votes returned exceeds the number of accredited voters. The petitioners shall rely on this on the report of statistician. They also pleaded that many voters on the voter register in the 11 focus states were disenfranchised on various allegations of violence, manipulation, and compromise. The law is now settled that the only way to prove overvoting, inflation, or deflation of votes at the polling units, manipulation of voters' register by INEC officials, as pleaded by the petitioners, can only be proved and by a petitioner by tendering voters' register and the forms EC8As and all other relevant forms used in the election to enable the petitioners show that if the figures of scores representing overvoting is removed from the declared result, the petitioner would win the election. The petitioners in this case have not done so. They tendered no voters register. No. And the only forms they tendered from EC8As, 8Bs, EC8Cs, and EC8As were not utilized or demonstrated before this court by any of the 62 witnesses called by them. There is no doubt that this is detrimental to the petitioner's case. The petitioners have also made an allusion to the fact that the first and second respondent rested their defense on the evidence given by the petitioners and submitted that they are deemed to have abandoned their pleadings and admitted the petitioner's case. I have dealt with this issue in the course of this judgment and found that it cannot be said that the first and second respondent abandoned, the first and third respondent abandoned their pleadings or that they have conceded to the petitioner's case. No facts and evidence on record has shown that the petitioners have discharged the initial burden of proof cast on them by law under Section 131 to 136 of the Evidence Act 2011 and the Electoral Act and regulations and guidelines made thereunder in respect of any of the grounds upon which the petition is premised. It is true, as borne out by the record, that the evidence elicited under cross-examination of the petitioner's witnesses by the first and third respondent established their defense to the petition. The evidence elicited on facts and issues joined on the petition and replies of the parties go to support the pleadings in their defense. It is also pertinent to deal with the submissions of the respondents or the respondent that the petitioners merely dumped the document tendered before the court on these particular issues without relating them to any aspect of their case, and as such the court cannot deem them to approve their case. The court cannot help the petitioner to do their job. The Learned Senior Counsel to the petitioners argued to the contrary and contended that having tendered the documents from the bar, they become evidence. I have long dealt with this, and the law is now firmly settled that when taken from the bar or by a person who is not the maker value, unless the makers are called to testify on the documents and answer questions in cross-examination on them. This is the position of the law. The respondents are therefore right in their submission that the petitioners dump all the Forms EC8C series and other documents on this court. None of them was utilized by any of the witnesses who testified on behalf of the petitioners in order to demonstrate the specific areas, particularly that relate to issue 4 and 5 in paragraph 107 to 387. All the experts, like I said in the earlier portion of this judgment, which were not demonstrated or linked to specific areas that relate to issues 4 and 5 of this petition, remain dormant and of no probative value to the petitioners. In the final result, for reasons set out in this judgment, I have come to the conclusion, which is inevitable and unavoidable, that the petitioners, on the basis of the evidence adduced before this court, have not proved any of the grounds contained in paragraph 15 of the petition as required by law. Failure by the petitioners to satisfactorily discharge the burden or onus of proof placed on them by law, this petition is liable to be and is hereby dismissed in its entirety. Before I end this judgment, let me also place it on record, and I would like to commend the Learned Senior Counsel for the parties, for their industry, and the brilliant final addresses on the issues conversed in this petition, which were very helpful to the court in the determination of this petition. We appreciate the cooperation of all the Learned Senior Counsel and other counsel who appeared before us in this petition throughout the conduct of the proceedings before the court. Parties in the petition shall bear their respective cost of prosecuting this petition. My learned brother to my immediate right will pronounce his decision in respect of this petition.
I took part in the conference linked to the judgment. I agree entirely with what has just been read.
My learned brother to my immediate left will pronounce his decision in respect of this petition.
I agree with the robust judgment pronounced by my learned brother Mohammed Lawa Garba, JCA, with the addition of these few words by way of emphasis. Paragraph 15D and E of the petition have read that, I quote, D, the second respondent was at the time of the election not qualified to contest the said election. E, the second respondent submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the said election, end quote. Section 138, subsection 1A and E of the Electoral Act 2010, as amended by the Electoral Amendment Act number 25 for 2015, states thus, I quote, an election may be questioned on any of the following grounds. That is to say, A, that the person whose election is questioned was, at the time of the election, not qualified to contest the election. E, that the person whose election is questioned had submitted to the Commission affidavit containing false information of a fundamental nature in aid of his qualification for the election, end quote. The RW2, Mr. Suleiman Issa Mayadua, who was 77 years old at the time of his testimony on 30th of July 2019, swore that he was one of the classmates of the second respondent at the Katsina Provincial Secondary School, now Government College Katsina, between 1956 and 1961, where English language was the medium of communication, and that they wrote their examination in 1961 upon reaching class 6 in the state secondary school. The evidence of the RW2 was not discredited under cross-examination. A witness of 77 years old, such as RW2, is indeed an old man who, in virtue of advanced age, will lay on the side of truth. See in Waguba against Enemo, 1988, 2N WRA Part 78, page 581 at 595, where the Supreme Court heard per the judgment prepared by Nameka Agu, JSC, as he was now of blessed memory thus, I quote, "It is a matter of common knowledge that old men often find it difficult to trace the truth," end quote. Accordingly, I accept the uncontradicted evidence of RW2 to the effect that the second respondent was indeed one of his classmates at Katsina Provincial Secondary School, now Government College Katsina, between 1956 and 1961, where they sat for their final examination upon completion of class 6. Educational qualification for election to the office of President of Nigeria is stated in Section 131, subsection D of the 1999 Constitution as altered. Thus, I quote, "A person shall be qualified for election to the office of President if D, he has been educated up to at least school certificate level or is equivalent," end quote. The educational threshold of, quote, "school certificate or is equivalent," end quote, in section 131D of the 1999 Constitution as altered is interpreted in section 318 sub 1A and B thereof in these ways, I quote, "School certificate or is equivalent means inter alia at least A secondary school certificate or is equivalent, or grade 2 teacher certificate, or girls certificate, or B, education up to secondary school certificate level," end quote. The court, that is this court, the Court of Appeal, Koram, Obadina, Sanusi, Ogboagu, JJCL, had cause to interpret a similar provision in section 106 of the 1999 Constitution, relying on section 318, 1A and B thereof in the case of Digai and another against Nanchang and others. Citation supplied per Obadina, JCA, thus I quote, "What is required under the law is that there must be evidence that a candidate is educated up to the school certificate level, and not that he must produce a certificate to that effect," end quote. There's also the case of Bayo against Injida, citation supplied, where it was heard by Ogboagu JCA, thus, I quote, "As regards a secondary school certificate level, one does not have to pass the secondary school certificate examination. It is enough, in my view, that one attended a secondary school and read up to the secondary school certificate level, that is without passing and obtaining the certificate," end quote. There is again the case of Chukwu against Chionwo, citation supply, where his lordship occurs, JCA, now JSC, while interpreting section 99 of 1 of the local government, bracket basic constitutional and traditional provisions, and bracket decree number 36 of 1998, which is similar to section 318 of the 1999 Constitution supra. On the phrase, quote, "school certificate or its equivalent," end quote, here thus, I quote, "It is not absolutely necessary that such a person must possess a certificate to enable him function effectively," end quote. Generally, there is a rebuttable presumption of literacy. A person is presumed literate until the contrary is proved by the person doubting or challenging that person's literacy. See the cases of Anaizo against Anyaso, then Otituju against Governor of Ondo State, then Jubosu against Obadina, then Ezego against Awudu, then Sunday against FRN, all citations applied. No scintilla of evidence was brought by the petitioner to rebut the presumption of literacy in favor of the second respondent that he attended education at least up to secondary school level in 1961 as stated on oath by the RW2. The second respondent therefore possessed the minimum educational qualification under section 131D of the 1999 Constitution, read with section 318 sub 1B thereof, to contest the said presidential election. The information given on oath by the second respondent to the first respondent, that is INEC, is to be P1 from CF001 on his educational qualification reads, quote, schools attended / educational qualification with dates, attach evidence of all educational qualifications. Yes, and that my one school primary qualification, primary school certificate, year 1952, 2 secondary, that is WASC 1961, then 3 higher, officer cadet 1963. The affidavit accompanying the information is the P1 from CF001 on educational qualification sworn to by the second respondent reads, I quote, that I am, number one, that I am the above named person and deponent on this affidavit herein. 2, that all my academic qualifications as filled in my presidential form, present APC/001/2015, are currently with the Secretary Military Board as at the time of this affidavit. 3, this affidavit is made in good faith and for record purpose, end quote. The information given by the second respondent to the first respondent is to be P1 from CF001 was on the submission of his primary school and secondary school certificates to the military at the time of his enlistment in the Nigerian Army in 1963. Giving false information and affidavit that amounts to lying on oath, it is a criminal offense under section 156 of the Penal Code, which provides thus, I quote, whoever being legally bound by an oath or by any express provision of law to state the truth, or being bound by law to make a declaration upon any subject, makes any statement verbally or otherwise which is false in a material particular and which he either knows or believes to be false or does not believe to be true, is said to give false evidence, end quote. The next stage is on the proof or the allegation that the information by the second respondent to INEC is the P1 from CF001 on educational certificates is false. This is a criminal allegation which is directly an issue in the election petition, which must be proved beyond reasonable doubt or with lesser-like precision by the petitioners who had asserted in the petition that the information on the educational qualification of the second respondent given on oath by the second respondent to the first respondent is P1, that is from CF001 is false, with the section 135 of the Evidence Act 2011, that evidence which provides us is part of the judgment taken as read. See also the cases of Mohammed against Wamako and others, citations applied, Ikpiaz against Oti, citations applied, Saleh against Abba, citations applied, Mehaja against Gaidam, citations applied. It is tried that he who asserts has the burden to prove the assertion or allegation. And if the allegation or assertion is criminal in nature, it must be proved beyond reasonable doubt by the person asserting it. See the case of Zakala against a dozen and another, citations applied, pre-release judgment prepared by his lordship, Echo JSC, to the effect that proof beyond reasonable doubt is not established by mere assertion. Furthermore, the Supreme Court, while considering similar issue inter alia of false declaration in the case of Mehaja against Gaidam, citations applied, heard the lead judgment prepared by his lordship, Bagay, JSC, now His Royal Highness, the Emir of Lafayette, inter alia that, I quote, the necessary question is what must a party prove to succeed on the allegation of false declaration? The nature of evidence required in this kind of situation is similar to that of mathematical precision, or 2 multiplied by 2 equals 4. 2 times 2 is equal to 4, end quote. See also the guy against Nanchang Supra at 64, where the court held that, I quote, as I had indicated earlier in this judgment, This issue revolves on the other issues already treated by me, but in specific hinges on the complaint of an alleged giving false information to a third respondent by the first respondent. Firstly, giving of false information either to the police and in this instant case to the third respondent certainly amounts to an allegation of committal of a crime. Again, the standard of proof is beyond reasonable doubt. See section 138 of 1 of the Evidence Act, end quote. The quantum of proof beyond reasonable doubt will therefore be proved with mathematical precision, as stated by the Supreme Court in Mehaja against Gaidan, Supra. The petitioner sought to prove the allegation of false information by relying on Exhibit P24, a copy of the Vanguard newspaper of 21st of January 2015, where it was reported that the late judgment captured it, so I will not repeat it, but it's my judgment too. The petitioners further relied on Exhibit P25, a Vanguard newspaper of 1st November 2018, where similar information as contained in Exhibit P24 was quoted by one Ikechukwu Amechi, who described himself as a MD/editor-in-chief, the niche on Sunday newspaper Ikeja, Lagos, in their bid to establish the allegation. The petitioners again relied on Exhibit P80 video clip purporting to carry the same information as Exhibit P24, where the Director of Army Public Relations, the same Brigadier General Olajide Laleye, gave a press briefing on the said issue contained in Exhibit P24 in pursuit of the allegation. Proof beyond reasonable doubt of criminal allegation in question required the evidence of the military secretary or secretary military board who is in custody of the service records personal file or the second respondent, and or by tendering evidence a certified true copy of the service records personal file or the second respondent as secondary evidence, or perforce by tendering evidence the original service records personal file or the second respondent through its custodian as primary evidence of what it contains. In other words, any document in the custody of a public servant, such as service records personal file or second respondents kept by the military secretary or secretary military board, should be proved by tendering evidence a certified true copy of the service records personal file or the second respondents in accordance with the provisions of sections 102B, 104, and 106 of the Evidence Act as secondary evidence of what the service records personal file or second respondent contains, or by tendering evidence the original file itself through the custodian thereof as primary evidence of what the service records personal file or the second respondent contains. In addition, the video clip Exhibit P80 is a piece of documentary evidence under sections 83 and 258 of the Evidence Act, and required it to be tendered evidence through the maker of the statement or recorder of the interview or message who has personal knowledge of the matters dealt with by the statement, or in performance of a duty to record information supplied to him by a person who had or might reasonably be supposed to have personal knowledge of those matters. None of the conditions in the proviso to Section 83 of the Evidence Act were met in this case. I highlighted the proviso there, and it's part of the judgment taken as read. So Exhibit P80 has no probative value. See Madueke against Okoraf and other citations supplied. The Supreme Court also heard in the case of Adegbite against the state, citations supplied, but the late judgment prepared by His Lordship, Galumje JC, that I quote, the lower court was also right when it refused to accord probative value to the newspaper report and radio interview, as newspaper report is not always the truth of the contents, end quote. Exhibits P24, P25, and P8 therefore lack probative value. The RW1 Major General Tarfa retired. One of the military corpsmates or the second respondent gave evidence under cross-examination by the first respondent that education certificates were not submitted to the Nigerian Army during their enlistment to the Nigerian Army in 1963. The evidence or witness, such as the oral evidence of RW1, who is not the custodian of the state service records, prisoner file, the second respondent, would not suffice as proof of the criminal allegation beyond reasonable doubt or with mathematical precision. The comment under section 156 of the Penal Code reads, I quote, comment, Pakistan Penal Code section 191, Sudan Penal Code section 167. 1. This section defines the giving of false evidence, known as perjury in English law. Part of the quotation is still taken as read. It is my modest opinion that once the alleged false statement is made on oath, as in an affidavit, its quality of being made on oath will bring it within the meaning of perjury, and thus under the ambit of the underlying comment number 1, supra. Because the legal consequence of lying on oath in an affidavit is a crime of perjury, proof of it requires corroboration under section 202 of the Evidence Act. Corroboration being an issue of evidence exclusively for the legislative powers of the National Assembly, pursuant to item 23 in the exclusive legislative list contained in the second schedule to the Constitution of the Federal Republic of Nigeria, 1999, as altered. Such statement on oath, that is affidavit, if alleged to be false, would require corroborating evidence in proof of it as provided under section 202 of the Evidence Act. Proof beyond reasonable doubt would have, at the risk of repetition, entailed the testimony of the custodian of the service records, personal file, or the second respondent with the Nigerian Army, and or evidence of certified true copy of the said service records to establish the allegation of giving false information by the second respondent, the first respondent in form CF001 Exhibit P1. See, by analogy, the case of Muhammad against Umar Supra, with the judgment prepared by His Lordship, Kekere Kunjesi, while considering the case of alleged forgery or educational certificate and giving false information to the effect that proof beyond reasonable doubt or the allegations would require evidence, be it documentary or by communication, from the organization or authority concerned disputing the information. The petitioner did not list such evidence to prove the state allegation with certainty or mathematical precision. This would have amounted to prove beyond reasonable doubt or prove with mathematical precision or the allegation whether the second respondent submitted his primary school certificate and his West African school certificate to the military secretary or secretary military board or the Nigerian Army upon his enlistment into the Nigerian Army as an officer cadet in 1963, and would have corroborated the evidence of RW1 as required by section 202 of the Evidence Act. Accordingly, even if the evidence of RW1 has some weight, the said evidence contradicted affidavit evidence on which the allegation of false information is predicated should have been corroborated by trustworthy evidence, as circumstances were not proved to corroborate the said admission made by RW1 under cross-examination. I conclude that the said allegation of giving false information by the second respondent to the first respondent as P1 from CF001 was not established beyond reasonable doubt. Bribery is an electoral offense under section 124 of the Electoral Act. It is a corrupt practice within the definition of the phrase rendered by the Supreme Court, the case of Yusuf against Obasanjo, citation supplied per the judgment prepared by His Lordship Acholono JSC as follows, I quote, the term corrupt practices denote or can be said to connote and embrace certain perfidious and debauched activities which are really felonious in character, being redolent in their depravity and want of ethics. They become hallmark of a decayed nature lacking in conscience and principles, end quote. The PW 28 testified of vote buying in that local government area of Bauchi State, while PW 30 testified of vote buying in Zaki local government area of Bauchi State. Also, the PW 32 testified of vote buying in Ningi local government area of Bauchi State. The PW 29 testified of vote buying in Biliri local government area of Gombe State, while the PW 43 testified of bribery of ANEC collection official in Agaragu Tofa Ward in Lafayette local government area of Nasarawa State. The witnesses Supra did not mention the names of any of the voters whom they saw bribed. The court, this court, comprising Ete, Ways, and Ademola JJC, heard in the case of Allega against Edun 1978 NN LRs page 17 and page 26 that the names of the voters whom the witness saw bribed must be given in evidence before allegation of bribery would be heard to have been proved beyond reasonable doubt. The Supreme Court also heard in the case of Wazira and another against Geda and others, citation supplied, following the case of Nyako against Balewa, citation supplied, and Alege against Edun Supra, that allegation of bribery or corruption must be proved by the accuser beyond reasonable doubt by evidence identifying by name the voters that were bribed. Subsection 1A and B of Section 124 of the Electoral Act also require that the alleged bribe be given or offered to a voter. Therefore, it becomes necessary that the name of any of the voters whom the witness saw bribed must be given in evidence. This is to ensure that the corrupt practice of bribery was actually effected on a registered voter or voters not at large for the purpose of illicitly swaying the voters' free choice of candidate in the election in order to maintain a sanitized electoral process that will be to be conducted in a free and fair manner and on level playing ground. There is no convincing evidence that the alleged bribe givers acted with the knowledge and consent of the second to third respondents or with the knowledge and consent of a person that acted under the general or special authority of the second to third respondents with reference to the election as required by Section 124, Subsection 6 of the Electoral Act, which, for emphasis, states that a candidate will only be held responsible for bribery or if the offense was committed with his knowledge and consent or the knowledge and consent of a person who is acting under the general or special authority of the candidate with reference to the election. Clear and unequivocal proof of allegation of bribery was also not made out by the petitioners, as it is not sufficient to suggest that the mere fact that somebody else bribed other persons to vote for a particular candidate was enough and conclusive evidence against a candidate in an election, as such a candidate cannot be held responsible for what other people did in the form of unsolicited aid or which he or his acknowledged agents were ignorant. See Zodo against Audu, citation supplied. There was therefore lack of concrete evidence to establish that the second and third respondents personally committed a corrupt act of bribery or aided, abetted, or counseled or procured the commission of the alleged corrupt practice of bribery. Nor was it established that the alleged act of bribery was committed through an agent that was expressly authorized to act in that capacity or granted a general or special authority to act in that capacity on behalf of the second and third respondents. Nor did the petitioners establish that the alleged corrupt practice of bribery substantially affected the outcome of the election to warrant nullification of the election of the second respondent, vide Section 139, Subsection 1 of the Electoral Act, and the cases of Auda against INEC, Buhari against Obasanjo, Abubakar against Yaradua, Oke against Mimiko, Akeredura against Mimiko, Ngige against INEC, all citations applied. The PW59, the Kenyan witness, admitted he obtained the information contained in his P87, P88, P89 from a whistleblower's website which had hacked permitted the colloquialism, the website of the first respondent. The bottom line is that the information and data upon which the PW59 based its analysis of the results of the election contained in his P87, P88, and P89 were sourced from the website of the first respondent, a public body, by means of hacking its website by a whistleblower. The website of the first respondent is doubtless a document within the meaning of Section 258, Subsection 1 of the Evidence Act, which defines document as any device by means of which information is recorded, stored, or retrievable, including computer output, end quote. Proceeding on the footing that the ultimate source of the information and data contained in P87, P88, P89 were illegal or obtained from the website of the first respondent, the computer printout of the information and data is P87, P88, and P89 should have been certified by the first respondent, a public body in custody of a public document, as secondary evidence under section 102, 104, and 105 of the Evidence Act as amended. It will be P87, P88, and P89 were not certified, therefore they have no evidential value. See Kobo and another against Dixon, certificate supplied. Per the lead judgment prepared by His Lordship Onogan, JSC, later CJ, and thus I quote, the fact that the exhibits are computer printouts or e-documents does not change their nature and character as public documents. His Lordship Ogumbi JSC had this to say in his judgment, I quote, also on the same footing is the document exhibit L, which is a computer or internet-generated document allegedly printed by the appellants from the website of the third respondent. As rightly submitted on behalf of the respondent by virtue of section 102, Roman 2 of the Evidence Act, such document is classified as public document and only a certified true copy of same is admissible in evidence. It follows therefore that the two exhibits D and L share the same fate and are rendered of no legal effect. The lower court was therefore on sound footing in upholding the tribunal's stand by expunging these documents. The following authorities are relevant in support: NIPC Limited against Thompson Organization Limited, Kankia against Megemu, and then Owoniya against Omoto Show, all contained in the quotation. Besides, the PW59 admitted that information or data upon which the expert evidence is in course, his base was hacked by a whistleblower from the first respondent, from whose website the witness derived the information and data that formed the basis of his analysis, containing exhibits P87, P88, and P89. Sections 14 and 15 of the Evidence Act as amended state, quote, evidence obtained A improperly or in contravention of law, or B in consequence of an impropriety or of a contravention of law shall be admissible unless the court is of the opinion that the desirability of admitting the evidence is outweighed by the undesirability of admitting evidence that has been obtained in the manner in which the evidence was obtained. 15. For the purpose of section 14, the matters that the court shall take into account include A, the probative value of the evidence, the importance of the evidence in the proceeding, that is B. C, the nature of the relevant offense, cause of action or defense, and the nature of the subject matter of the proceedings. D, the gravity of the impropriety or contravention, and E, whether the impropriety or contravention was deliberate or reckless. F, whether any proceeding, whether in bracket, whether or not in a court end bracket has been or is likely to be taken in relation to the impropriety or contravention. And then G, the difficulty, if any, of obtaining the evidence without impropriety or contravention of law, end quote. The website of the first respondent from which the information that was hacked, being any device by means of which information is recorded, stored, or retrievable, is the document under section 258 subsection 1 of the Evidence Act, which should have been accessible to the petitioners for inspection for the purpose of filing and maintaining the election petition under section 151 of the Electoral Act, empowering the court to order for inspection of electoral documents and or any other documents in the custody of the first respondent. See Latoja against Ajimobi, citation supplied. Consequently, the petitioner had no basis to subtract the law by benefiting from the hacked website of the first respondent through the machination of the whistleblower, thus resorting to self-help, which the Supreme Court deprecated in the case of Governor of Lagos State against Ojukwu, citation supplied. The law also frowns at a party benefiting from a wrongful act. Further, in the case of Totti and Opabi against Opabi, citation supplied, Niagolo GSC expressed reservation on placing weight on evidence obtained by felonious means or by breaking the law, as in this case. The criminal case of Sadao against the state following Privy Council case of Krumah, son of Kani, against the Queen on the propriety of illegally obtained evidence by way of illegal search of an accused person has to be appreciated against the background that criminal law addressed to all and sundry and is for the protection of society in the pursuit of which the state and the citizenry are stakeholders. Therefore, incriminating relevant evidence found on an accused person by illegal means will meet the ends of justice or ground of overriding public interest for the protection of society by the state using the illegally obtained evidence to prosecute the accused, whose remedy may lie in a civil action for damages against the state for the illegal search. In the present case, the petitioners deliberately and recklessly relied on the hacked information and data in question when it would have been convenient for the petitioners to have followed due process under Section 151 of the Electoral Act to inspect the document and obtain certified true copies thereof at the time the first respondent's website was hacked before the petition was filed, thus breaching Section 15 of D, E, and G of the Evidence Act. Based on the discussion so far, I respectfully place no weight on exhibits P87, P88, and P89 as they are a product of unjustifiable and illegally obtained evidence by means of hacking the website of the first respondent by the whistleblower using his website, through whom the PW59 improperly obtained the information and data contained in exhibits P87, P88, and P89. The PW60, the statistician, is not competent to analyze and produce report or editing results and alleged malpractices afflicting them, though presented as an expert witness. His evidence on documentary analysis of the electoral document is P98 to P90J, therefore have no evidential value. See Ladoja against Ajumobi, Supra at pages 142 to 144. I quote Ugumbi JSC there. I'm quoting, PW1's report or inspection is replete with analysis of election materials, and at the end of each table, he gave analysis and opinion and conclusion of the materials analyzed by him. This is evidence at pages 4397 and 4398 of volume 5 of record reproduced earlier in the course of this judgment. The analysis of the smart card reader accreditation, PVC, collected and votes cast on each table in each local government is made from pages 3611 through 4371 of the volume 5 of the record. The witness, PW1, is also not qualified to analyze or subject to forensic scrutiny electoral forms, results, and documents in the manner he did. In the case of Buhari against INEC, certificate supplied on somewhat related matter, the Court of Appeal, without much ado, rejected the appellant's report because he was not qualified to analyze INEC documents. The lower court at pages 386 to 389 of the report wasted no time in rejecting the documents. Also, in the recent decision in AC 409/2012, our Share Congress gave Rear Admiral Murtala H. Nyako and others delivered on November 12, 2012, reported in 2012, APELR 19649 SC or 2015, 18 NWR Part 1491, then page 352. This court, in a similar situation, rejected the evidence was statistical analysis of a witness who described himself in his statement on oath as a graduate of economics, a consumer banking officer, and a retail financial analyst, and heard thus. They are quoting the PW66 by qualification and learning is not an expert in the art of establishing multiple registration and voting elections, special skill in respect of which would have been entitled him to assist the tribunal to form his opinion on the point, end quote. See also the case of NPP against Osman, certificate supplied, where the judgment prepared by His Lordship Aboki, JCM. The RW Force attention was drawn under cross-examination by the petitioner's learned senior counsel to the first name, quote, Mohammed, end quote, on Exhibit R19, the Cambridge Assessment International Education Certifying Statement, while the first name of the second respondent in the petition is, quote, Muhammadu, end quote. There should be no fuss over the name Mohammed and Muhammadu because, as held by the court, that is Quran Msofo, Ikongbe, Onogen, Mikaelu, Nwuta, JJC in Alliance for Democracy against Fayoshe, certificate supplied per the lead judgment replied by Nsofo, JCA, thus, I quote, and I ask this, what really is in a name or a name? Cuculus non facit monachum. Now name derived from Latin nomen nominis in its noun form. See Chambers 20th Century Dictionary, page 875. Is defined to mean, quote, that by which a person or a thing is known and called a designation, end quote. Of the big quote continues. Of what concern or to whom does it matter if it chooses to be called or known by many names or very many names? I confess that I know or no legislation or a decree in Nigeria restricting the persons to a number of names he may be called or known by no such law, end quote. It is therefore not in doubt that the document exhibit R19 bearing the name Muhammad Buhari refers to one and the same Muhammad Buhari, the second respondent in the petition. In the result, I too concur that the petition has not been proved as required by law and deserves to be dismissed, and hereby dismiss it and abide by the consequential orders contained in the judgment pronounced by my learned brother Garba JCA.
My learned brother to my extreme right will now pronounce his own decision in respect of this petition.
Well, I agree with the conclusion contained in the legal judgment as per the fate of this petition. The facts are well spelled out therein, and I do not intend to repeat them. However, I deem it expedient to further address the issue of whether or not there existed a server for use by the first respondent, as well as the relevance of smart card readers during the 2019 general elections. The petitioner's stance is that by their utterances, news briefings, and the manual, as well as guidelines for the conduct of election, it is not in doubt that the first respondent intended to and did make use of smart card readers and the server for the electronic transmission of election results during the 2019 presidential and National Assembly elections. The law is straight that he who asserts must prove such assertion. See Section 1361 of the Evidence Act 2011. So also Awuse and Odili, Mogaji and Odofin, Elias and Omodare, Daudu and NMPC, with citation received. In Adigije and Mwogu, this court, Ogumiju JCA, held that, and I quote, Section 137 of the Evidence Act 2004 provides that for a burden of proof in civil cases, the burden of first proving the existence or non-existence of a fact lies on the party against whom the judgment of the court will be given if no evidence were produced on either side, regard being had to any presumption that may arise in the pleadings. If such party adduces evidence which might reasonably satisfy a court that the fact sought to be proved is established, the burden lies on the party against whom judgment will be given if no more evidence were adduced, and so on successively until all the issues in the pleadings have been dealt with, unquote. See also M.O. Kanu and Sons against Nzeribe with citation, Abaji, JCA, then now JSC. The quotation is here, but I do not intend to, it's taken as having been read. The petitioner's hearing had pleaded in paragraphs 26 to 29 of their petitions as follows, and they said they are quite extensive, but I will take them as having been read. The first respondent in response averred in paragraph 15 and 16 of the first respondent's reply to the petition as follows. I also detail the averments of the first respondents in my own contribution. In the light of the above set out averments, there is no doubt that issues were strongly joined on the existence or non-existence of a central server, and whether the results of the presidential election, which held on the 23rd of February 2019, was electronically transmitted. The petitioners in support of their pleading in this regard called PW2, PW3, 4, 12, 16, 17, and 36. The evidence are inclusive here. PW2 testified that he was an ad hoc staff of the first respondent, and he worked as registration area technician RATEC and ward collation officer for Ward 5, Constituency 2 of Ogbaegbe Mandoni local government area of Rivers State. He stated that before the election day, he was trained by the first respondent, INEC, on the use of the smart card reader at the election. The smart card reader was to be used at each polling unit for the mandatory accreditation, verification, authentication, collation, and transmission of results of the election. And that apart from one polling unit in the ward, where there was a snag, the smart card was used in all the other polling units for accreditation, verification, authentication, and collation of results of the election. He, however, admitted under cross-examination that he did not function as a presiding officer or assistant presiding officer. PW3 also was an ad hoc staff of the first respondent, who testified that he was employed as a presiding officer, PO, at the Civic Center Amoji polling unit, which is code 005 in Amoji Ward in Enugu East local government area of Enugu State. He added that he was trained by the first respondent on the mandatory use of smart card readers for authentication, collation, and transmission of results of the election at the polling units, and that upon conclusion of voting and collation of results, he transmitted the results of the polling units electronically to the first respondent server using the code or password provided by the first respondent and as directed. He, however, stated under the cross-examination that he was not told the name or number of the server, but all he knows is that he transmitted the results to a server. PW also gave similar evidence on the use of smart card reader at the election, as he deposed in his statement on oath that he electronically transmitted the results of the election into the server belonging to the first respondent using the code or password as provided. He agreed also during the examination that he did not state the number of the smart card or server location in his statement on oath. PW12 testified also that he was a polling agent for the petitioners in Tanko Kutawan polling unit of Chanchaga local government area of Niger State. He stated that in his polling units, election commenced with the use of smart card readers, which later broke down and resort was had to manual authentication of voters on the directive of the presiding officer. PW16 also testified that he was an ad hoc staff of the first respondent and worked as assistant presiding officer, APO, for Wako polling unit 001 in Kwali, local government area of the Federal Capital Territory. He stated that the election was conducted by a smart card reader and the result of the election was transmitted electronically to the first respondent server using the code also provided by first respondent after verification by the respondent's area technician. He also stated under cross-examination that though he transmitted results to the servers, but the server number was not given to him. PW17 equally in his statement of oath deposed that he was the first respondent ad hoc staff during the election at an APO. He was engaged as an APO at the local LEA primary school, Galadima/Gwarepa polling unit, FCT, where the card reader was used for accreditation, verification, authentication, collation, and transmission of votes through the first respondent server by the code provided by first respondent. He also stated during cross-examination that he was told during training that the server belonged to the first respondent, though he was not given the server number. Lastly, PW36 testified the evidence also that he was an ad hoc staff of the first area presiding officer, APO1, where he used the smart card reader in his polling unit and equally transmitted the election results electronically to the first respondent server via the smart card reader. His response during cross-examination was that he was trained to transmit results to INEC and although he did not personally see the server, he was told about it by the first respondent. On the other hand, the first respondent did not call any witness to support their pleadings in this regard, but rather opted to rely on the petitioner's case via the evidence elicited during cross-examination. The second and third respondents also did not call any evidence to support or deny the existence of the first respondent's server, which is very clear. Though I'm not so mindful of the tri-state of the law, that a party can rely or rest its defense on the evidence given by a claimant during cross-examination. But this is premised on the condition that such evidence must relate or derive from the facts adverted to in the pleadings. The bottom line here is that neither the first respondent specifically nor the second and third respondents called any evidence to add life or flesh to the facts in denial as adverted in their pleadings with regard to the use or non-use of the smart card reader or server. The law is long settled that where issues are joined on any averment, but no evidence is laid to support such, the end result is that such averments are deemed abandoned and prone to be struck out. See Omoborewo and Ajasin, Magnuson and Koiki, Cameroon Line and Otutu is with citation inclusive, also Adunsi and Bambala, and Amechi and INEC. On this premise, the position of the law is succinctly stated by the Supreme Court. Aloma Mukhtar JSC, later CJN, now retired. In the case of New Breed Organization Limited against Eremosele, 2006, 5 Nigeria Weekly Law Report, part 974, at page 499, as follows. Quote, when a defendant refuses to adduce evidence in his defense and rests his case on the evidence of the plaintiff, then he has himself to blame if the trial court finds for the plaintiff based on his evidence as was done in the instant case. The position of the law is that where an adversary fails to adduce evidence to put on the other side of the imaginary scale of justice, a minimum evidence adduced by the other side will suffice to prove its case. See Brahimo and Bangbose and Nwabuoku and Otis with citation, unquote. In the instant case, the respondents, as particularly the first respondent, refused or neglected to adduce evidence on the vexed issue of whether or not smart card readers were used during the 2019 elections, or that there exists a central server, but opts to rest their case on the evidence as adduced by the petitioners. The consequence is that there is no other evidence to put on the other side of the imaginary scale to judicially weigh the evidence on both sides of the divide. It follows, therefore, that the evidence as adduced by the petitioners in support of their pleadings, as earlier detailed, will be taken as sufficient proof that smart card readers were used during the presidential election which held on the 23rd of February 2019. What is more, Section 15.2 of the Electoral Act 2010 as amended in 2015 states as follows. 15.2, I quote, voting at an election under this Act shall be in accordance with the procedure determined by the Independent National Electoral Commission, unquote. Pursuant to the above provisions, the first respondent introduced Exhibit P27, that's regulations and guidelines for the conduct of elections, and Exhibit P28, Manual for Election Officials 2019, also Exhibit P33. The set exhibits contains rules and regulations to guide the first respondent officials in the conduct of the elections, and this includes the use of smart card readers to verify permanent voters' card and authenticate them before voting, as shown in paragraph 8B of Exhibit P27. Other relevant paragraphs are 10, 13, 28, and 29. The same goes with chapters 1, 2, and 3 of Exhibit P28, which contains specific procedures to be adhered to before, during, and after close of voting, as well as transmission of results and accreditation data using the smart card readers. That said, I'm, however, not oblivious of the present state of the law as enunciated by the Supreme Court in Yesonwike against Peace Aside, 2016-7 Nigeria Weekly Law Report, Part 15-12-452, or 2016 LPLR 40,036 Supreme Court, wherein Kekere Kun JSC stated as follows, and I quote, I had stated earlier in this judgment that INEC is to be commended for the innovation of the card reader machine to bolster the transparency and accuracy of the accreditation process and to maintain the democratic norm of one man, one vote by preventing multi-voting by a voter. Nonetheless, Section 49(1) and 2 of the Electoral Act 2010 as amended, which provide for manual accreditation of voters, is extant and remain a vital part of our electoral law. The section provides thus, any person intending to vote with his voter's card shall present himself to a presiding officer at the unit in the constituency in which his name is registered with his voter's card. 2. The presiding officer shall, on being satisfied that the name of the person is on the register of voters, issue him a ballot paper and indicate on the register that the person has voted. In the recent decision of this court in Shinkafi and Yari Supra, Okoro GSC stated thus, my understanding of the function of the card reader machine is to authenticate the owner of a voter's card and to prevent multi-voting by a voter. I am not aware that the card reader machine has replaced the voter's registrar or has taken the place of statement of results in appropriate forms. Again, which the GSC, Nokereke and Umahi and others, unreported Supreme Court 1004/2015 delivered on the 5th February 2016, reiterated the position as follows, quote, indeed, since the guidelines and manual, Supra, which authorize the use and deployment of the electronic card reader machine were made in exercise of the powers conferred by the Electoral Act, the said card reader cannot logically depose or dethrone the voters' registrar whose juridical roots are firmly embedded or entrenched in the self-same Electoral Acts from which it, bracket, voters' registrar, directly derives its sustenance and currency. Thus, any attempt to invest it, that's the card reader machine procedure, with such overreaching preeminence or superiority over the voters' registrar is like converting an auxiliary procedure into the dominant procedure or proof that is proof of accreditation, unquote. That's per Kekereku. See also the case of Emmanuel Udom and Umana, number 1, 2016-12 Nigeria Weekly Law Report, part 1526-179. The quotation is there as quoted part of the judgment there. Also, their Lordship Rosevival GSC also addressed the issue at page 86 and 87 of the same report. And in INEC and Peter side, Mohammed JCN as it then was also stated, and I quote, however, in the present case, the first and second respondent petitioners only relied on the second leg of paragraph B of section 138(1) of the Electoral Act 2010 as amended to claim that the election in Rivers State was invalid only for failure of the officials of the appellant to comply with the appellant's order on them to use smart card readers for accreditation of voters for the election, which the respondent petitioners failed to relate to any provisions of the Electoral Act to qualify as non-compliance with the provisions of the Act. In this regard, I am of the view that the first and second respondents / petitioners failed to prove their case at the election tribunal, that the failure to use smart card readers for accreditation of voters at the election had the effect of nullifying the entire election in Rivers State, unquote. Okoro JSC also made its own contribution, and the same with Sanusi JSC, the portion of which I reproduced in this contribution. I also refer to the case of Shinkafi and against Yari, 2016 LPLR 26050 Supreme Court decision, where the Supreme Court stated that the function of smart card reader is solely to authenticate the owner of the voter's card and to prevent multi-voting by a voter. and cannot replace the voters' register or statement of results in appropriate forms. See also Ogboru and Okowa, 2016-11 Nigeria Weekly Law Report, part 1522-84 at 129 per Okoro JSC. And I set down the quotation, the portion of the judgment here. In the light of the above set out decisions, which represents the extant law vis-a-vis smart card readers as a means of proving non-voting, overvoting, transmission or non-transmission of election results, the issue of smart card readers in the present discourse serves only the purpose of helping to improve the accreditation process during election, and as such complements the procedure set out in Section 49 of the Electoral Act 2010 as amended, which provisions, I dare say, does not include recourse to a central server for the purpose of collation or declaration of election results. This point finds expression in Section 63, 65, 69, and 74 of the Electoral Act 2010 as amended. Section 63 provides, said, the presiding officer shall, after counting the votes at the polling unit, enter the votes scored by each candidate in a form to be prescribed by the Commission as the case may be. 2, the form shall be signed and stamped by the presiding officer and countersigned by the candidates or their polling agents where available at the polling unit. 3, the presiding officer shall give to the polling agents and the police officer where available a copy each of the completed forms after it has been duly signed as provided in subsection 2 of this section. And 4, the president shall count and announce the result at the polling units. Then Section 65 said, after the recording of the result of the election, the presiding officer shall announce the result and deliver same and election materials under security to such persons as may be prescribed by the Commission. Then 69 said, I quote, in an election to the office of the president or governor, whether or not contested in any election to any other elective office, the result shall be ascertained by counting the votes cast for each candidate, and subject to the provisions of Section 133, 134, and 179 of the Constitution, the candidate that received the highest number of votes shall be declared elected by the appropriate returning officer. Then Section 74 concludes. He said, every result form completed at the ward, local government, state, and national levels in accordance with the provisions of these acts or any guidelines issued by the Commission shall be stamped, signed, and countersigned by the relevant officers and polling agents at those levels, and copies given to the police officers and the polling agents where available. The resultant effect of the above set out provisions is that collation of results are to be done manually, and declaration of such results are to flow from the figures as entered in the relevant forms at the various levels of collation. It is not dependent on the content or use of a smart card reader for the transmission of election results. Hence, Section 74 specifically provided that every result form completed at the polling units, ward, local government, and state and national level shall be stamped, signed, and countersigned by the relevant officers and polling agents at those levels, and copies given to the police officers and polling agents where available. Albeit, and for the purpose of posterity, the first respondents serve the interests of the generation now and generation next. I will emphasize again that to all intents and purposes, the law requires or mandates the first respondent to operate a website under Section 71 of the Electoral Act, which provides as follows, and I quote, the Commission shall cause to be posted on its notice board and website a notice showing the candidates at the election and their scores, and the person declared as elected or returned at the election, unquote. The above set out provisions use the word shall which connotes mandatoriness or command. See Shetima and Goni, and Uba and Suswam, as well as Onochie and Odogu with citations. Furthermore, the posting of the results must be on the notice board and website. The word "and" is conjunctive, which means that the result must not only be posted on the notice board, but also on the website. A website is defined by the English Dictionary Online Edition as, quote, a computer connected to the internet that maintains a series of web pages on the World Wide Web, unquote. It also defines a server as a digital computer that provides workstations on a network with controlled access to shared resources, unquote. In the light of the above clarifications, it will not be out of place to emphasize that as a fact, duly proved as earlier indicated, and by law, as per the Electoral Act 2010 as amended, there exists a website managed and controlled by the first respondent. The above clarification, however, notwithstanding, I also hold that the petitioners did not adduce sufficient evidence to justify the grant of the relief sought. Thus, the petition is also hereby dismissed, and I abide by the consequential orders made in the late judgment, including the order as to costs.
My learned brother to my extreme left would now pronounce his own decision in respect of this petition.
I completely agree with the comprehensive and incisive judgment delivered by my presiding justice, M.L. Gabra, PJCA, as it contains enough details to show that in all respects, the petitioners have failed to establish or prove any of the relief sought by them, either in the main or in the alternative.
Gentlemen, we have noticed several errors that are contained in the judgment which I delivered. We shall undertake corrections of the judgment and then give parties copies, clean copies after the corrections.
My lords,
yes, Dr. Udoku.
my lords, may I start by commending your lordships for the industry exhibited in the rulings and judgments delivered today, lasting, by my calculation, for a little over 8 hours. I sincerely believe that this must be the longest sitting of any court in this country and the longest judgment in the annals of jurisprudence and judicialism in this country. My lords, let me also thank my lords for the opportunity given to us to present our case, and also commend my lords that the petition at least was not allowed to expire, because that is very, very important to us as petitioners, and we are grateful.
You're welcome.
My lords, having said this, my lord, the presiding justice had already promised that in the shortest possible time we will get the rulings and judgments.
Yes, you will.
In the next 24 hours.
we shall get the corrections made soonest as soon as possible.
Ascot, please.
It's even better in our own interest to get finished with these judgments so that we can all go back to our respective divisions.
Ascot, please. Once again, I thank my lords.
We shall do that.
Thank you, my lords.
You're welcome.
My lords, as we have always shown, we are neutral. But my lords, sincerely, we must thank your lordships for two things. This is one of the rare occasions we have where everybody, including my boss, Livy, are given too much latitude to do anything we can do here legally. My lords, we must be very grateful to all of you, my lords. My lords, we are grateful. The second thing, sir, my lords, we want your lordships to pray to us so that this analytical mind will come to, not me again, no, we are finished, to the little ones, because the way these things have been analyzed, my lords, some of us are happy that we are not on the bench. I can't do it. Honestly, I cannot do it. Lastly, my lords, we are so grateful that it is a unanimous judgment. And for INEC in particular, my lord, we are happy that all my lords say, INEC, you are right not to have transmitted results electronically. My lords, we are grateful.
All right. Electronic transmission of results.
My lord, on behalf of the second respondent and also our leader, Chief Olanik Pekon, who is unavoidably absent on account of being out of jurisdiction, we would like to thank my lords for very, very detailed, painstaking, insightful, and also refreshing rulings and judgments. My lord, there are lots to be taken away. Having regards to the volume of the judgment and rulings, it is not unexpected that there will be errors. But I want to confirm that the errors we are talking about are just typographical errors and not anything substantial. Maybe for the benefit of all concerned, that they are typographical errors and not anything substantial that has to do with the substance of the judgment. I take it that way because once your lordship has been, your lordship are functions officials.
Yes.
Except to correct typographical errors.
Let me just say,
yes,
that this is common knowledge.
yes, sir.
Not correct our errors on law, on the facts. That will be for
Whatever. My Lord, we thank my Lord for everything. All we can say is that, my Lord, may God just continue to refresh and energize you. Because it's been about almost 8 hours. Almost 9 hours. All of them taken together. Everybody has been able to sit down and look at the whole thing, and from on this side to say thank you and thank you and thank you for being on the side of justice.
Oh, please, we say something.
Media. My lords, we also thank you. You are not owing us, rather, we are the ones owing you. We thank you for commending us, and I'm happy, even if my clients don't pay me. They will pay me though, and they have been paying. Yeah. Yes, my lords, the chairman of APC, when we went out, he said, I didn't know that judges are also surgeons. I said, yes, I am happy you are in court. My lords are surgeons. The surgical operation you did was very methodical. I can continue on and on. It is well that this judgment is unanimous. It is well that all the stems, roots, and branches of the case have been refused. What? I wish you well, my lords. I can see that you are all young men, But when you grow old, I pray that, like the glory of sunset, your night will be peaceful. Thank you.
I say young man. Eh? Well, gentlemen, on a final note, we also like to thank you for all the kind words on commendation from the court. But primarily we take it as a primary constitutional and national responsibility that we have been called upon to undertake and make sacrifices in our own little way towards the development of this country. And we assure you that we are always ready to do so. And we look forward to meeting all of you at some other fora. Thank you very much. Everyone ready? Everyone ready. The court will now rise.
Court!
Come on, please.
I dash you one.
By the content of the judgment, but the truth will. Time, I do not know if we have had a judgment that has been